Oh. These 3 days we'll have to rise early in the second half. We'll be sitting in the second half for maybe for 1 hour maximum.
My lord,
Okay.
I'm paying for listing of a matter, my lord. I'm in the case as an opposite party. There is stay against us, and the matter is not coming up in the list, my lord.
Matter, what matter?
My lord, the CRPIO, and there is a stay against the proceeding, my lord. So may I pay for listing of the matter in the next Friday, my lord?
Matter of which year?
My lord, 2024.
24. When was it filed?
Last it was listed on 9/2/2024.
9/2.
Yeah, after staying the my lord proceeding, no listing, my lord. Matter was not listed.
Next Monday.
My
My lord, I pray for listing tomorrow of a matter.
Huh? Mr. Sikdar, next Monday is a holiday, I think. I've been
Monday.
told.
Then, my lord, Wednesday?
Next Wednesday.
My lord, I pray for an listing tomorrow. My lord, my only predicament is that day after tomorrow is the date of execution, my lord.
Fresh matter.
Fresh matter, my lord. In fact, I have filed it on 14/3. It came up on 3rd, 3, 4, but it did not reach.
CRP.
No, my lord, it is an RSA.
RSA. Concurrent findings.
No, reversal finding.
Okay, we can have it tomorrow.
And it-
May I please, Lord?
Yes. Yes.
May I please, this matter is a RSA matter in 2015. The matter was listed for hearing on several occasions, but not listed. The matter was a RSA one.
2015 matter.
Yes, ma'am.
It will come up for orders on Friday. We'll fix a date for hearing.
Master.
May I please, your lordship? I'm praying for a listing of a CRP IO, my lord. The pending matter, your lordship,
Of which year?
2022.
22.
It was last listed on 6/12/2022 and hasn't been listed again, my lord.
Okay, we'll have it on Friday.
Obliged, my lord.
May I please, your lordship? I beg to mention one IA indemnity application. It's a 2016 matter.
Okay.
The execution, the decree was issued by this honorable court, and due to which the applicants did not enjoy the fruits of the decree, for which I beg to mention. I have been filed an early hearing on 13/5/2023.
They're not listed.
No, my lord.
IA for early hearing has not been listed.
No, my lord.
Okay, we get it listed. Can have it day after tomorrow.
Highly obliged.
May I please, your lordship? Lordship, I want to list case number RSA 112/2016 for hearing.
16 matter. RSA. You for whom?
Respondent.
Respondent. Okay, we'll have it on next Wednesday. Not this Wednesday, next Wednesday. Okay.
Obliged.
Okay. Give the date. I think 19th. Okay.
May I please, your lordship, prayer for listing of an FAO. This is a 24 matter, but it is a dispute for an movable property, a truck which is lying in the garage. An injunction order has been given that the truck cannot be moved from the garage until the end of the suit. My lord, it may be listed any day next week.
Okay, 19th.
May I please, your lordship, I beg to mention an RSA which has been listed in the part 2 hearing list, lordship.
Part 2.
Lordship,
What
in
part 2? Is there any part 2?
Civil
No.
bench 1, lordship, hearing list, lordship, hearing lordship, lordship.
There is no hearing list nowadays.
Lordship, there is one civil bench 1, it has been listed.
Photo say এখন আমার দিয়া না আমার ফটো দিয়া না এটা এখন আজি আছে টপ অফ দ্য লিস্ট না হিয়ারিং লিস্ট কোড হলে তো it's not there, it's not published, it's in the website. You tell us what do you want?
Lordship, there the item 33, we have filed a substitution petition, lordship, substitution of legal error. It's a RSA, lordship.
You file a mention memo, we'll have
Lordship, I
that.
have a mention memo. The
Okay.
matter may come up Friday if
Okay,
possible.
okay,
Much obliged, lordship.
okay.
My lord, I beg to mention on fresh matter, my lord. The execution proceeding is going on, and it is at the last stage, my lord. Therefore, my lord, here I have filed CRP, my lord. It is regarding this case, my lord.
When did you file?
My lord, the main case has been filed in the month of December, my lord. But due to some defect, it was lying. My lord, defect has been.
You don't clear the defects for 6 months.
No, my
And you-
miss case has been filed, my lord. Last for stay, my lord, it is filed on yesterday, my lord.
Yesterday?
Yes, my lord. And that is, my lord, I have.
Okay, on Friday. Friday we'll consider.
May I please, my lord?
I beg to mention, my lord, one RSA, my lord, for withdrawal, my lord.
Withdrawal.
Yes, for tomorrow, my
Tomorrow it may not be possible to locate the file. Day after tomorrow.
lord.
Okay.
Lordship, for listing of a matter, RSA
Of which year?
of fresh
New matter.
new material.
Okay. When did you file?
I filed it on 23/11.
2311,
Yeah,
not
but
yet listed.
It is not listed.
Have you checked that regarding any defects?
Yes, we have checked and we have cleared it.
Okay, well, we'll have it on
Maybe take
Friday.
it up on Friday.
Friday.
Lordship, kindly fix the matter at 2 o'clock. My senior is on leg. He's doing part-heard matter in court 4.
Who is your senior?
Mr. J. Roy.
Okay, at 2 o'clock sharp, second half maximum 1 hour we can sit, okay?
Oh, yes, Lord.
There 2-3 days, there's some administrative interview. Okay. 2 o'clock. 2 o'clock, Mr. Singh. Here for the respondent.
Yes, sir.
2 o'clock. Hearing or first item 20 material labor.
May I please, your lord. Lordship, I seek your indulgence, my lord, in this matter. Earlier set of advocate, my lord. Mr. N or Mr. S. Chakraborty and D. Malakan. Your lordship, Mr. Dorin is out of station, my lord. He remained in Vrindavan, my lord. And Mr. Chakraborty, my lord, is suffering from brain stroke, my lord. And so, my lord, earlier occasion, my lord, I entered appearance before this honorable court, my lord, without Bukalam Lama, my lord. I have not been empowered to only requested, my lord. That's my lord. I want accommodation, my lord. Let the matter come after, my lord. Vacation in the meantime, I will appear, my lord. I have find out the file.
2009 matter. What are you seeking? What is your, what
Kindly
submission are you
accommodate, my lord.
making?
Otherwise, I will be.
2009 matter, we're not going to adjourn these matters, top of the list matters. And you are asking after the vacation, what is this kind of submission?
My lord, I shall have to.
You may not have a formal wakalatnama. If you submit that you have been entrusted to appear, we'll accommodate you. Mr. Dhar is not there, doesn't matter. You do the case.
But my lord, yesterday, my lord, I have find out the file, even file.
Yesterday till today, enough time. You don't need,
Before your lordship.
we don't need 2-3 days to prepare a case. It's a 2009 matter. It's very embarrassing.
Exactly, my lord.
Our High Court doesn't have that pendency. And if we don't take a step now, it will be like any other High Court. And your assistance is of most importance for us. You do the case, start the proceeding while we are there.
My lord, no. Ask them, my lord.
Don't ask for a time like this. Okay, Thursday, but
I'll appear.
Thursday, no accommodation.
Mal.
Okay, a prayer for adjournment has been made by Sri Theolaskar,
Mal.
Learned Counsel, who has submitted that he has been instructed to appear
Mal.
on behalf of the appellant. Full stop para. Considering that this RSA is of the year 2009, while the prayer for adjournment is declined, a small accommodation is granted till Thursday next
Mal.
date, huh? List on so and so.
Hello.
Under the column top of the list.
Mal. Oblige.
Record আছে নি? পড়ো record আছে no? Record নাই? আছে আছে। This appeal is of the year 2004. Full stop. None appears for the appellant, whereas the BJ Mukherjee led counsel appears for
Respondent number one.
respondent number one.
One.
One. Full stop. Para. When the matter was listed on the last occasion, that is I 7/6/2024, a prayer for adjournment was made, and as an exceptional circumstances, comma, the matter was adjourned till today. Full stop. Para. It appears that the appellant is not interested to pursue this appeal. Full stop. Appeal accordingly stands dismissed for want of prosecution.
One more. May it please your lot.
Yes, please.
Lordship, this is a matter pertaining to some land dispute your under the Mohammedan law, your lot. So your lordship will find there is a dispute also with regard to the date of the vendor, your lordship, from whom I purchased the land.
Date of death
Date of the
of your vendor.
vendor, your lordship. And defendant number one is the son of vendor. He has, after the death of his mother, from whom I
No,
purchased
the appellant, how many appellants are there?
the appellant, only
One appellant. You are the plaintiff.
Plaintiff appellant, your lordship.
Okay, appellant is a plaintiff.
Yes.
Suit was for?
Your lordship, there are so far respondents are concerned, your lordship. One respondent main, your lordship, the others are so all performer respondent.
Okay, suit was for? Suit was for?
Suit was for declaration of right, title and interest, confirmation of possession and permanent injunction, your lord. Lordship, I am coming to the plaintiff, your lordship, at page 6.
Yes.
Relief's claim is at page 11, your lord. The plaintiff therefore pays for a decree, for the declaration and confirmation of plaintiff's exclusive inherited and purchased right, title and possession over the suit land mentioned in schedule below. And for declaration and confirmation that the defendant number one has no right, title and interest over the suit land as his mother Gulab Jan Bibi exhausted her entire paternal property by sale to the plaintiff by registered sale date number 2480 on 23/6/86 over the suit patta, including the other pattas, and after her death, the father of defendant number one claiming Foni and Perez transferred the rest land of his wife by sale to the plaintiff on 12/4/2001 by deed number 1006. Grant all cost of the suit, grant permanent temporary mandatory injunction restraining the defendant and their agents from disposing the plaintiff from the suit land by any means and restrain them from discharging the plaintiff in maintaining the exclusive peaceful possession and enjoyment over the suit land, and further restrain them from changing the present feature and structure of the suit land, and further restrain them from causing injury or damage to the suit land, your lord. So this is the pair, your lord. These are the pairs. And on this pair schedule, your lord, you will find, this is important here. Schedule district PS and sub-register Hailakandi Moza Vishnu Nagar Vishnu Gaur, the Suitland measuring area 4 Vigha oats covered by duct number 96, second RS quarter number 17, which is bounded by Sasin Chapter. So it is 4 Vigha and oats. Now, as against that, your lordship, the defendant number 1, he filed written statement with a counter claim, claiming that when the plaintiff purchased the land from his mother was not alive. So his mother died in the year, according to him, 1978. And as such, there is no question of executing or selling any land in the year 1986 by his mother. So this is basically the dispute, your lordship. And the court, while deciding this dispute order, did not actually decide it as per law. And the documents they also produce, your lordship. That is document number, our document is exhibit 27. And their document is exhibit Shaw. As per their document Shaw, your lordship, it is 1978. And as per our document, it is 86, your lordship. Now, your lordship will find in both the counts,
These exhibits are death certificates.
lordship, death certificate.
Death certificates.
Death certificate 27, it is this plaintiff's
Your exhibit is 27.
27
Where
plaintiff.
as per you, the death was in 1986.
86, your lordship, it is 23/6/86.
23? No, 23/6 is the date of the deed. It cannot be 23/6.
Date, your lordship, it is 12/8/86 according to exhibit 27.
12/8/86.
12/8/86
Okay.
according to the
And
plaintiff.
exhibit Shaw says,
And exhibit Shaw, your lordship will find, it is 4/5/78. It is their document, your lordship.
yes.
Now, if this dispute is actually resolved, your lordship, on the basis of these two documents, then matter is clear. Now, the court, your lordship, ignored how to prove document, your lordship. They have also produced from the same authority, we have also produced from the same authority. And after the date of vendor, your lordship, her remaining properties were distributed as per the Mohammedan law, and her husband also got some land, and husband, again, by a second deed, your lordship, in the year 2001, transferred and sold it to the plaintiff, your lordship. Now, in every dispute in such a manner, your lordship, in such dispute, your lordship, it is the duty of the court, your lordship, to bring the register or the volume, your lordship, from which this certificate, because these two documents, that is exhibit 27 and exhibit Shaw, your lordship, both are secondary evidence. Because this secondary basis is certificate given from the original volume or the original register. So now, original register, if it is all for your lordship and it is scrutinized, your lordship, as per the law, inquiry is made, your lordship, then it would have been the proper course of consideration, your lordship, by the courts below. But both the courts below, your lordship, believe the exhibit Shaw, your lordship, and disbelieve exhibit 27. And why believe and why disbelieve, your lordship? To that there is no explanation. And whatever explanation has been given, your lordship, that is not actually as per law. Now, question is probative value, your lordship. The probative value of both the documents. May I read your lordship, appellate court judgment, your lordship?
Both the court has ruled against you.
Lordship.
Concurrent finding.
Concurrent finding, but finding on this law, this is a law point, your lord, basically. So under the law, your lordship, what is how a document is to be proved? Question is, your lordship will find admission of a document and proof of a document, your lordship, two different things. Admission, it may be numbered, it may be given a number, your lordship, exhibit number. So for the proof is concerned, your lordship, content must be proved. So contents they fail to prove, your lordship, whereas on the other hand, I have proved, your lordship, the content as well as the other document also, that is the
Your document exhibit 27
lordship,
was proved by whom?
by the plaintiff himself, your lordship.
Did you call for any officer from the registry? You did not.
It was not called for your lordship. Similarly, they also did not call for your lordship. So it is very difficult on the part of the court below your lordship to arrive at a finding in such a.
You did not call for the registry people. They also did not call for the registry
Yes, your
people.
lord.
So how did the court arrive at a conclusion? Which document is to be believed? How did it come to the conclusion?
Come to conclusion that without any explanation, your lord, so far the trial court judgment is covered, it is considered the document as well as the evidence. So far the appellate court judgment is concerned, your lordship, it has vetoed the judgment and the findings of the
Trial court.
trial court. So there is actually failure of order 41 rule 31, your lordship, because there is no point for determination, decision and reasons for decision.
Points were not framed for determination by the appellate court. No, that is a different question, but we come to the basic question, how the documents are to be proved and
Gotcha.
why exhibit Shaw was preferred over exhibit 27. We'll examine that consideration. What was the consideration for believing exhibit Shaw and disbelieving exhibit 27?
27.
Yes. Let us see the discussion.
Lordship.
Let us see the discussion in the judgment.
Lordship, page 44. The appellate court judgment.
Yes.
Judgment at page 45. This title appeal is preferred by the appellant plaintiff being aggrieved and dissatisfied with the judgment and decree dated 18/11/2005 passed by the civil judge, senior division, Hailakandi, entitled suit number 28 of 2002, whereby the aforesaid title suit was dismissed with cause. The plaintiff appellant preferred this appeal on the following grounds: that the learned trial court, while deciding the aforesaid title suit, did not consider at all the exhibit exhibited by the plaintiff appellant and also did not consider the exhibit 27, that is the official report of the joint director and register of birth and date, Hailakandi, wherein the date of Gulabjan Bibi, that is my vendor, your lordship, and my mother of defendant number 1. The mother of the respondent number 1 is 12/8/86, and due to non-consideration of the aforesaid paper, it was not possible to show that the aforesaid person was alive on or after 23/6/86. Further, the learned trial court did not consider the evidence on record in proper perspective of law and thereby arrived at a wrong finding as to the possession of the respondent in respect of the suit led. This apart, the learned trial court also could not consider the law of limitation in proper perspective, and as such the impugned judgment and decree has no legal footing to stand for, which is same is not sustainable in the law. Notices were issued to the respondent and also LCR was called for after receipt of the notice.
You come to paragraph 13 at internal page 8.
Paragraph 13.
You read from paragraph 11, internal page 8.
Paragraph 11.
Paragraph 11.
Issue number 1 was.
No, page internal page 8, para 11, the death certificate. Internal page 8, paragraph 11.
So, yes, so issue number 1.
No, para 11 it starts, the death certificate is issued. Next page, again, there are 211, sorry, there are 211, you are correct.
Oh,
Kindly turn over the page.
Paragraph 11 is
Repeated, okay, doesn't matter. The death certificate.
The death certificate is issued as per provision of the registration of birth and date Act 1967, it should be 69, Your Lordship.
Yes, doesn't, yes.
And the same is issued under section 12 and 17 of the State Act. Section 12 of the State Act reads as follows. Extracts of registration entries to be given to the informant. The register shall, as soon as the registration of a birth or a death has been completed, give free of charge to the person who gives information under section 8 or section 9 as expected of the prescribed particulars under his hand from the register relating to such birth and death. Section, again, subsection 2 of section 17 of the State Act reads as follows. All extracts given under this section shall be certified by the registrar or any other officer authorized by the state government to give such extract as provided in section 76 of the Indian Evidence Act 1872 and shall be admissible in evidence for the purpose of proving birth and death to which the entry relates. Now, on perusal of Exhibit 12 and Exhibit 27, it appears that Exhibit 27 appears to be an administrative order to issue the death certificate after realization of charge fees as per the rule. However, the date of death mentioned in the same is 12/8/86. On the other hand, Exhibit 2 is the certificate of death whereby the date of death of one Gulabjan Bibi was mentioned as 4/5/1978. Exhibit 27 does not bear the certificate, whereas Exhibit 2 bears the certificate as required under the provisions of law laid down as indicated above. Further, the Exhibit 27 cannot be deemed to be certified extract of the register of birth and death as required. As required under the provisions of law of the land, and thus neither can be deemed to be a public document nor admissible in evidence. On the other hand, Exhibit 2 on the very face of it has fulfilled the aforesaid requirements of law of the land. In the result, from this preponderance of the evidence, Exhibit 2 has established a clear as over it, Exhibit 27. Thus, it is evident that Gulabjan Bibi expired on 12/8/86 but on 4/5/78. Thus, it is evident that Gulabjan Bibi expired not on 12/8/86 but on 4/5/17. The aforesaid fact has been also indirectly revealed during the trial. So, courts mainly confined to the certificate given in the Exhibit 2 and certificate not given in Exhibit 27. Fact remains, Your Lordship, whether both the certificate is given or not, because it is not our knowledge, in what way a date of birth or date of registration, date of certificate is to be given, Your Lordship. It depends upon the authority concerned, Your Lordship, from which actually they prepared it. This being a secondary evidence, Your Lordship. So, primary evidence must be called for, Your Lordship, because without the primary evidence, Your Lordship, secondary evidence cannot be called, Your Lordship, or cannot be held also, Your Lordship, that it is 100% true. Now, when the dispute is genuine, Your Lordship, now Your Lordship will find our documents, Your Lordship. No, certificate do not have to Lordship, this was given, your lordship, exhibit 27, your lordship, it was given by the registrar birth and date, your lordship, Alakpur, Alakpur Health Center, your lordship. Mrityur Tarikh 12/8/1986, Mrityur Sthan Balipur. Husband's name Mosaddar Ali Borbhuya. Khai Bahastan Thikona, Balipara, Part 3, Post Office, Balipur District, Hailakandi. Dated, your lordship, the signature date 29/12/89. Now your lordship will find the main, your lordship, points to be decided here, your lordship. Ponjion or Tariq, your lordship. Ponjion or Tariq, your lordship, 29/12/89. She died on, according to this document, 12/8/86. Ponjion or Tariq, that is the date of registration, is 29/12/89. Now your lordship will find exhibit show. Now exhibit show, your lordship, it has been. So for the information given is concerned, your lordship, it is after the institution of the suit. I am coming, your lordship, that is Chaw. Gulabjan Bibi, female, date of death 4/5/78, place of death Baliapur Part 3, Ponjion number 334, date of registration 12/9/2002. According to them, she died in the year 1978. And date of registration is, your lordship, that is 2002. So from 78 to 2000, your lordship, 22 years. Then 24 years, after 24 years, information given to the date of register of date of birth. And who gave it, your lordship? There is a Supreme Court decision to the effect, your lordship. It is important. Who gave the information? When the information was given? And what is the relation between the informant and the person expired, your lordship? Here, after 24 years, your lordship, they informed the register of date and birth that so and so died on such. Then who actually, why? Why after 24 years, they actually informed the register of birth and death to register the date of such and such person, your lordship? That is a strong point, your lord, that you, for which it cannot be believed. Why actually after such a long time? Because she was not such a, say, notable person or such a lady, your lordship, that somehow.
When was the suit executed?
Lordship,
When was the suit executed?
suit,
The suit was instituted?
lordship,
When was the suit instituted? Which year?
suit is of the year 2002, your lordship.
2002.
Two, your lordship. It is 2002, year 28 of 2002.
In that year, they have got it registered.
They inform the register of date of birth, and this is manipulated document, your lordship, just for the purpose of the suit they obtained it. So unless, your lordship, it is specifically, your lordship, corroborated by the original register or say the volume wherever they have actually noted the registration. Unless that is called for in both the cases, I think there cannot be any finding, your lordship. Why such delay, your lordship, that has been ignored, that has been actually oversighted.
No, what is the discussion on the delay part?
No discussion.
No discussion.
No, not at all, your lordship.
Was there any other evidence on the deaths?
Any other evidence, your lordship, that is viable evidence, the dependable one has given my mother died on such.
No, other than his evidence.
Nothing. No one, your lordship, because his father died long back. His father, your lordship, again sold his share derived from, inherited from his wife, to me. So as a result, your lordship, I got 4 bigha and not plus 1 bigha and not. That means the entire share of Gulabjan Bibi, because Gulabjan Bibi's father, Ashraf Ali, your lordship, he was the owner of 33 bighas and odd lessons of land. 33 bighas.
So he left behind 2 sons and 2 daughters. So her share is 1/6, that way comes. So 1/6 is 5 bigha. So 5 bigha, 10 kata, 6 sotaks. It is Hailakandi, that is sotak is used to a lot, and Gonda is also there. So her share is 1/6, that comes to 5 bigha, 10 kata, and 6 sotak. Now, without the corroboration by the original document, or any officers actually who recorded the registration, and the person who informed the office that so and so died on such and such date. Why he remembered that date, your lordship, up to 24 years, your lordship, and he had to inform the register of date and birth, your lordship, on that day, particular date, your lordship.
These two deeds of 1986 and 2001, those were registered deeds. Registered,
Registered deed, your lordship. Registered
which-
deed, your lordship.
by which you had purchased the property
Lordship.
from the mother of the defendant number one, as well as from the father
Father,
during their lifetime.
lifetime,
These are the registered documents.
registered document. These are registered document.
Yes, Mr. Hawk. Now, from the discussion in paragraph 13, we are not too much inclined to be with the plaintiff.
My lord.
But when Mr. Ali has pointed out that you got the death registered
2002.
into the year 2002 after institution of the suit.
That whether
But we are not saying that that is something very illegal.
Right.
But there has to be an explanation, number one.
that
And
is
number two, these both the deeds are registered deeds.
registered
So
by
there is a presumption that deed registered. So normally the whatever
it is
due
correct.
process of law is there, it has been fulfilled. Unless you make out a case
Okay.
that fraud was done, because it is registration has been done by a person who was no longer there existing. That person.
Exhibit 27, my lord, whichever
Mr. Ali will come back to you. Just have his response. We'll come back to you. Yes.
Exhibit 27 is not a death certificate. That reflected in the judgment.
No, you are correct. We have read paragraph 13.
Secondly, why doubt created, my lord, involved in this? The death certificate was issued. That first thing is that whether the same by exhibit 2 is correct or not, because it is a fraudulent date. It is the contention of the defendant in the counterclaim. Why exhibit 2 is fraudulent? First thing is the exhibit 27 and exhibit 4. And second ground is that whether exhibit 2 that sale deed was registered in a different district. It is not permissible under section 24 of the Registration Act. It is not within that jurisdiction. That is why doubt created, and that exhibit 2 was challenged. Second,
Which is exhibit 2?
exhibit 2 sale deed, he
Which
has
one?
purchased
23,686. Mother. Okay.
Mother.
This is exhibit 2.
deed, yes,
Exhibit 2, you say it was registered where?
in Silchar and the
Kachar district.
in Kachar district. And it is proved that no one was with my mother at the time of registration. It is proved already.
And the property is where?
Property is Hailakandi.
No, this aspect.
Second.
Yes.
Exhibit 2, that is the registered date, whether exhibit 2 was proved or not, that is also one of the question. No scribe, no any attesting witness, nothing, only exhibited those certified copy of the exhibit that sale deed. The original was not produced before the learned trial court. Their contention in evidence that it was destroyed. How destroyed, why how destroyed, that is not explained.
Who has said it was destroyed?
It is by them,
Plaintiff.
plaintiff.
Not by the official witness.
No official witness was called for from the sub-registry office to prove the exhibit 2. And no scribe, no attesting witness, nothing. Only it was exhibit.
Just a minute, please. Okay.
In page 15, paragraph 11, that is it.
Okay. Yes.
Your lordship, see page 37, paragraph 10 of Planet trial court judgment.
Trial court judgment.
Page 37, paragraph 10.
It starts at,
Internet page 737.
no, unfortunately, this page, our copy is not paginated. But it doesn't matter. It starts at which page? Give the running page of the, we'll just paginate it.
7 internal page.
No, not, so
37.
tell us the running page of the starting of the judgment, first page of the judgment.
It starts from.
Annexure 4 type copy.
Annexure 4 type.
What is the page number?
Page number 37, internal page 7.
No. Give the starting of the, that page only. Starting of the 32 it starts, okay. We'll have a continuation then. You are at 37.
37,
The
paragraph
internal page will be a
Seven.
7.
Okay.
Para number,
10.
main crux.
Nine.
This is 37 page.
The main thrust of this suit is that with the origin of exhibit 2 created by means of fraud. That is the case of the defendant. Apparently, the origin of exhibit 2 also issued by a competent authority, so genuineness of registered document is supposed to be duly executed and registered. So the burden lies upon the defendant counterclaimant to prove the fact of fraud. Under section 65C of the evidence, like a certified copy of sale deed may be proved where the origin was destroyed or lost. Hence, in the instance suit, except on an oral statement of the plaintiff, there is no proof that the origin exhibit 2 was destroyed. Therefore, even if we presume that the origin exhibit is stated by the PW1 was lost, it only proves execution, but contents of the document shall not go in evidence except it was duly proved by scribe or attesting witness as per section 67 of the Evidence Act. Here in the instance, the plaintiff did not make any attempt to examine the scribe, attesting witness, or identify to prove the contents of the document. As such, the mere making the documents as exhibit does not dispense with proof, and its aspect plaintiff utterly failed.
Okay.
Page 38, my lord, the paragraph, the second paragraph, it reveals what I have submitted.
It
It
reveals.
reveals from the materials on record that the parties to the exhibit 2 deed are the permanent resident of Hailakandi within 4 kilometers from Hailakandi sub-register office. But the plaintiff allegedly got registered the origin of exhibit 2 at Deputy Register Office Center at distance of 45 kilometers from their residence. Admittedly, Gulabdan Bibi was an old lady at the time of eldest execution and registration of origin of exhibit 2, and she was residing with her husband and son, defendant number 1. Plaintiff is his cross-examination admitted that on the date of registration, except him, none accompanied Gulabdan Bibi, including her son and husband. So all these facts created a doubt as to the conduct of the plaintiff, and genuineness of application. And it passed under section 25 of the Registration Act also, my lord.
Okay,
So for exhibit 27, my lord, it has declined because it is not a certificate. And so was accepted because it was certificate.
okay. Yes, Mr. Ali?
Your Lordship, this so far on proof is concerned, Your Lordship, this is the exhibit 2 and exhibit 3 by which I purchased, Your Lordship, 5 bigger not lesser.
Hmm.
It was never objected, Your Lordship. Without objection, it was admitted, Your Lordship. It was considered also by the trial court at the first. Now, this plea cannot be taken, Your Lordship. This secondary evidence. If it is to be objected, Your Lordship, by the trial.
But there was discussion by the trial court itself on the veracity of the seal deed. It was the subject matter of dispute in the counterclaim. And therefore, there was a discussion. The objection on the admissibility on objection, and will it dispense off with the requirement to prove the contents of the exhibit? You still have the burden to discharge regarding the proof of the contents. It was a certified copy, no problem. But the attesting witness or the scribe, nobody was examined. You said that the original was destroyed. So you are depending on the certified copy.
Lordship, it was destroyed. That's why, Your Lordship, পদক্ষেপ দুই আমার আমিও বিবাদীর মাতা গোলাপজান বিবির প্রদত্ত বিগত 23/6/86 ইংরেজি তারিখে খরিদ দলিলের স্বাক্ষরিত নকল আসলি নষ্ট হয়ে গেছে। আসলি নষ্ট হয়ে গেছে। So is the case, Your Lordship, the other one also, নকল যাহা বিবাদী কর্তৃক স্বীকৃত। So far, this is concerned and law will take its course, but so far, finding of this on exhibit 27 and for
Correct.
Your Lordship,
Yes.
it is a fit case for remand and let him be satisfied, Your Lordship.
Okay, we'll consider. We'll consider.
On the base-
Are you placing any decision?
And Lordship, not necessary if it is remanded, Your Lordship.
No, even to make a case of remand,
Lordship,
even to be successful in a submission for a remand, you may cite any decisions if you like.
to Your Lordship, I am just.
The decree is still stayed, Mr. Hawk?
What?
Decree, he was the plaintiff.
He's the
He-
plaintiff.
Okay,
I'm in pocket.
you're in position.
You are not in person. huh?
I'm
I'm in person. So
And I'm-
that is-
Both of you are in position, be
He is
happy.
also insisting that he is in position, I am insisting that I am in position, that's a confirmation of position. And his pair also a confirmation of position, so there will be no question of execution in the matter.
Mr. Hawk, are you submitting on instructions or what? That you're in position?
No, I on instruct.
Your senior colleague is also saying he's in position. I hope it is not a collusive suit. Both of you are in position. Okay, we'll close this. We'll consider
Apply.
third. Three. And any decision you'd like to cite or something? No. Any decision you'd like to cite? Not required.
Not
Okay.
necessary, Your Lordship, in this case, if it is remanded.
Okay. We'll consider your prayer. We do not know what orders will pass. Third Sri Asari Learned Council for the appellant. Also has Sri and Hawk Learned Council for the one respondent. For the respondent, the hearing is concluded. The judgment is reserved. No, key judgment reserved for DD we dictate the judgment, no point. The present appeal has been instituted, has been preferred against a judgment dated is it 18/11/2005? No. What is the date of the appellate court?
13/7/2010.
13/7/2010, passed by the learned district judge Hailakandi in title appeal number 6 of 2007, whereby the judgment and decree dated 18/11/2005, passed by the learned civil judge Hailakandi in title suit number 28 of 2002, has been affirmed and the appeal has been dismissed. Full stop. The appellant was the plaintiff in the suit. Full stop. Para. The suit was instituted for declaration of right, title, and interest, comma, confirmation of possession, and for permanent injunction. Full stop. It is the projected case of the plaintiff that land was purchased by the plaintiff from the mother of the defendant by a registered deed number 2480 dated 23/6/1986. Full stop. The plaintiff had purchased further portions of land by registered deed number 1006 dated 12/4/2001 from the father of the defendant, and on the strength of the aforesaid sale deeds, comma, the suit was instituted. Full stop. Para. In the present respondent as defendant, however, while defending the case, had also raised an issue towards while questioning the authenticity of the deeds. Full stop. It was contended that the mother of the defendant had passed away in the year 1978, and therefore the deed number 2480 could not have been executed in the year 1986. Full stop. The defendant had also made a counterclaim raising the aforesaid questions. Full stop. Para. The learned trial court vied the judgment and decree dated 18/11/2005 had, however, dismissed the title suit number 28 of 2002. What about the counterclaim?
But page 9, page 21. For
What happened to the counterclaim?
the defendant counterclaim has right title interest over the 4 bigger 19 Patha.
And decreed the counterclaim.
Yes, yes.
And the counterclaim of the defendant was decreed. Full stop. As mentioned above, comma, the first appellate court had also rejected the appeal, and thereafter the present appeal has been preferred. Full stop. Para. This court vied order dated 23/12/2010 had framed the following substantial questions of law. 23/12/2010, huh? Quote kori dibo. Para. Sri Ali, the learned counsel for the appellant, has submitted that the controversy was revolving on Exhibit 27, which is a death certificate dated 12/8/1986, exhibited by the plaintiff, and Exhibit CHA, which is also a death certificate dated 4/5/1978. Dated no. Don't say, which is also a death certificate wherein the date of death was stated to be 4/5/1978 and was exhibited by the defendant. Full stop. It is submitted that since both the aforesaid exhibits were certified copies, those were to be treated as secondary evidence, and without calling for the original register, a conclusive finding could not have been arrived at, whereby Exhibit CHA was given preference over Exhibit 27. Full stop. Para. The learned counsel for the appellant has also raised an issue that though wide Exhibit CHA, the date of death of the mother of the defendant has been stated to be 4/5/1978, the registration, the certificate was issued only in the year 2002, that is after 24 years, which itself raises
After the institution of this.
serious doubts on the authenticity of the said exhibit. Full stop. It is strenuously contended that such certificate having applied for and issued after the institution of the suit, the same should not have been taken into cognizance by the learned courts below. Full stop. It is submitted that both the sale deeds number 2480 dated 23/6/1986 and 1006 dated 12/4/2001 were duly registered, which itself raises a presumption in favor of the plaintiff that the title was duly transferred to the plaintiff vide registration of the said sale deeds. Full stop. Para. It is also submitted that there was no explanation, whatsoever with regard to the delay in registering the death of the mother allegedly in the year 1978 in the year 2002. Full stop. Para. Per contra, Sri N. Hock learned. I have heard bully. I have heard about Bushi too. Per contra, 3 N Hoc, learned counsel for the respondent, has submitted that while the appellant is trying to find fault with the manner of proof of the death certificates, the same would also be applicable in the for the exhibits 2 and 3, which were also not proved in accordance with law. Full stop. It is submitted that both the exhibits were only certified copies of the sale deeds, and except a bare statement that the original records were destroyed, there is no other materials to justify the stand of the defendant. Full stop. It is highlighted that no official witnesses were produced to prove the said deeds, and neither any attesting witness or any other person conversant with the said transaction was produced as witness. Full stop. Para. The learned counsel for the defendant has also raised an issue that so far as the exhibit number 2 is concerned, while the property is of the district of Hailakandi, the registration was done in the Kachar district, which itself is in contravention of section 24 of the Registration Act.
Lordship, at that time, whether there was this Hailakandi, Karimganj and Kasar 3 districts were there, Your Lord, at that time.
That is, we'll say something.
At that time, it was only Kasar district.
Okay. It is also submitted.
Because there was no territorial jurisdiction at that time.
Okay. It is also submitted that as per the evidence of the plaintiff, the registration while being done at Kachar, the vendor, that is the mother of the defendant, was not accompanied by any other persons, and she being an old lady, such person is apparently doubtful. Full stop. Para. Sri Ali, the learned counsel for the appellant, has however submitted that in absence of any materials as to whether in the year 1986 there was bifurcation
There was no bifurcation
of the districts, the aforesaid submission made on behalf of the respondent is not liable to be considered. Full stop. Para. The rival submissions have been duly considered. Full stop. Para. Para no. And the considered the record, the LCR which have been obtained have also been perused. Full stop. Para. The discussion made by the learned courts below on the first substantial question of law would reveal that while Exhibit Shaw was a certificate, Exhibit 27 was not a certificate. and was only an administrative order to issue such certificate. Full stop. For ready reference, comma, the discussion on the aforesaid issue made by the first appellate court is extracted herein below, paragraph 13, page 8, or pink flag. This court has also noticed that while coming to the finding regarding the acceptance of the exhibit Shaw over exhibit 27, comma, the learned court has also taken into consideration the provisions of section 12 and section 17 of the Registration of Births and Deaths Act. This is 1969. Not
69.
69, not 67, I think. 69. Full stop. Para. As regards the issue, as regards the question framed on the interpretation of the documents exhibit 2 and 3, comma, this court is of the opinion that except a statement made by the plaintiff that the originals were destroyed, comma, there are no other materials as to why no attempt was made to examine any competent witness who were conversant with the execution and registration of the two deeds. Full stop. It is submitted that both that that since the executors in both the deeds had passed away, comma, it was incumbent upon the party trying to get any benefit of those deeds to get the same duly proved in accordance with law. Full stop. This court is of the opinion that the discussion and findings that no attesting witness, scribe, and other persons conversant were not produced to prove the deed. Full stop. There is a specific discussion by the learned court on the aforesaid aspect on the following issue. Page 37, paragraph 10. 37 to be like paragraph 10. It was orange flag, which is extracted here in below. Full stop. Para. The scope and ambit of this court in exercising powers under section 100 of the Code of Civil Procedure is a limited one, and such examination is restricted to only substantial questions of law. Full stop. The Honorable Supreme Court in the case of so-and-so has held as follows. Full stop. Para. After considering the facts and circumstances noted above and by following the principles laid down by the Honorable Supreme Court on the aspect of exercise of jurisdiction, this court is of the considered opinion that the judgments of the trial court as well as the first appellate court do not suffer from any legal infirmity. Full stop. Accordingly, the substantial questions of law are answered against the appellant and in favor of the defendant. Full stop. The appeal stands dismissed. Send back the records. Okay.
Perfect.
তাহলে যে আমি ডিসিশন ওলাইছিল এটু কোড করে দেব ওকে নেক্সট
Lordship, Lordship, in this, Mr. Taidul has undergone dialysis, Lordship, and he has made a request to conduct the case only yesterday, Lordship.
Yes.
Maybe taken up day after tomorrow, next Tuesday, Lordship.
Okay. We'll have it day after tomorrow. So recently it has been engaged. Okay, day after tomorrow. Okay.
Just inform the other side also.
Okay. Sri. You otherwise you are there, Mr. Chakraborty? No.
No, I am not.
Sri B. Chakraborty, Learned Counsel submits that the conducting counsel is unwell and he has been requested to conduct this case. First stop. He, however, prays for some accommodation. First stop. Para. Also heard your name?
T.L. Chaudhary. On behalf of Amit Chaudhary.
You are A.N. Chaudhary.
T.L. Chaudhary.
T.N. Also heard Sri T.N. Chaudhary, Learned Counsel for all the respondents.
No, they are responding, all the respondents, yeah.
For the respondents.
Plenty of
Stop.
stuff.
For the respondents. Para. Let this appeal be listed for hearing day after tomorrow.
Mr. Ghosh is appearing.
Well, matter, where is he? Please call him. None appears for the.
Can take up after some time.
We'll fix it another day and we'll make an observation. If there is no further appearance, we'll dismiss this. 2012 matter, he should be here. Try to locate him. Okay, we'll wait for some time.
Okay.
It's again.
Who is for the appellant? You're for the respondent.
Respond.
Who is for the appellant? No idea. MBU Ahmed.
Fine.
Who is Mr. MBU Ahmed?
Hello, really. And the date may be fixed, my lord, here.
These are all matters,
My lord.
14 matters.
14 meter, my lord, but
None appears for the appellant on call. Whereas your HP Gwala,
my lord.
HP Gwala Learned Counsel is present for the respondent. Full stop. Para. In the interest of justice, this appeal is of the year 2014. Para. Be that as it may, in the interest of justice, the matter is adjourned to give a further chance to the appellant to be represented. Full stop. Para. List on Friday.
Right.
Next. Full stop. It is however made clear that in the event there is further non-representation, comma, this court would pass appropriate orders.
Obligement.
Me, please. Lord, 8 and 9 are connected, my lord. The two proceedings were instituted by each of the parties, my lord. Lord, item 9 perhaps would be if taken up earlier.
9 is the RSA.
9 is the RS. Twenty-nine 8/2013, my lord, two questions were formulated.
Just a minute. Appellant is who?
Appellant is the defendant.
Suit for?
Specific performance.
Okay, suit has been declared by both the courts.
By both the courts.
Which date?
29 8/2013.
29/8. Okay.
Now, my lord, may I take up the paint at page 30, my lord. The case of the
Just a
plaintiff-
minute, please.
Yeah.
Yes, what has happened?
My lord, page 30 is the plaintiff, my lord. Now.
30.
30. Lord, the case set forth by the plaintiff is straightforward, my lord. He says 29/7/2003, I executed an agreement for sale.
Just a minute, please. Page 30 is the
Page 30.
plaint.
Yeah, that's the plaintiff, my lord. And page 31, para 1, if your lordship please.
Yes, this is title suit of 34,
Yes, 34/2000.
2004.
Yes.
Where was it?
Nalbari.
Yes, what has happened?
My lord, page 31, my lord. The plaintiff narrates the agreement, my lord. He says on 29/7/2003, the defendant agreed to sell the plaintiff an area of land measuring 1/4 10 hectares with 2 rooms standing thereon for a consideration of 3,40,000, my lord. And out of that, he says he has paid 2,20,000 already, and he's ready and willing to pay the balance consideration. And he says that I have not executed the sale deed, and therefore he seeks specific performance.
He says that he paid 220,
220.
but he did not execute or done the remaining.
Yes.
Okay, okay. Then
Now, my lord, page 35 is my written statement, my lord. My lord, at para 6, if your lordship please.
35.
35.
Yes, please.
para 6, my lord.
Hmm. Yes.
If I may read, my lord. He says that at the time of execution of the agreement for sale, only 70,000 was received by this agreement from the plaintiff. The fact is that prior to this agreement, the plaintiff paid 1,20,000 in 3 installments
Hmm.
towards advance of the agreed amount. And in every occasion, the plaintiff and his son obtained signatures of the defendant in blank stamp papers. Subsequently, para 7, my lord. Subsequently, when the agreement for sale was executed, the plaintiff and his son demanded the interest and rupees 1 lakh on rupees 1,20,000 on the plea that the amount was paid much earlier. Finding no alternative, the defendant agreed to pay the interest, and in that calculation, the plaintiff fixed the lump sum interest over rupees 1,20,000 and an amount of rupees 30,000, and thus rupees 70,000 plus 1,20,000 plus 30,000, which is adjusted to the to be the advance amount of the land out of the agreed amount of 3,40,000. Now, my lord, he basically admits the execution of the sale deed, my lord, of the agreement for sale. I'm sorry. He only says that they had been advancing amounts to me much prior to the agreement, and on each such occasion, they had obtained signatures on a few blank stamp papers. And thereafter, the agreement was executed, but he did not return back the blank stamp papers. Well, there's also an admission which will probably trouble me. That is at page para 11, page 37.
Yes.
That the defendant is still willing and ready to execute the sale deed as per the terms of this agreement if the balance amount is paid by this plaintiff and the 3 blank stamp papers are handed over to the defendant.
Okay.
Now, my lord, I said that they had obtained blank stamp papers and there's an apprehension that those blank papers would be misused, and therefore, if they return us the blank papers, I'll execute the sale deed. Now, page 43 onward, your lordship will find 3 exhibits. The misutilization of the blank stamp papers. This is something which the trial court has more or less endorsed.
43.
43. Lord, this particular advocate, my lord, who represents the defendant, had sent 3 notices to me. Now, this is the first notice, exhibit core.
KA. Go.
Okay.
Yes.
Now, here, my lord, this is a notice on behalf of your lordship will mark under the instructions of my client Narayan Talukdar, the plaintiff, resident of so and so. I give you this legal notice that on 29/7/2003, your lordship will mark the date. You have entered into an agreement for sale of a plot of land measuring so and so to covered by so and so and so and so. So he's referring to this particular agreement of 29/7/2003, and he demands execution of the sale deed. The following document, that is exhibit for your lordship will find.
Next page.
Next page, my lord.
Another legal notice.
Another legal notice by that very same advocate. And this time he says, under the instructions of my client, Nirmal Talukdar, who happens to be the son of the plaintiff, son of Narayan Talukdar. He shoots another notice, and this time he says, that on 13/2/2002, an agreement for sale of property, which is specifically mentioned in the schedule below, entered into between you and my said client, that as per the terms of the said agreement, the value of the property was fixed at 3 lakhs, out of which my client paid an amount of 2 lakhs in advance. So here he's referring to another particular agreement of 13/2/2002, purportedly entered into between the son of the plaintiff and the defendant. Then finally, at page 46, my lord.
Yes.
That is exhibit Ghaur, my lord. There's a third notice by the same advocate. And this time he says, under the instructions of my client of a third person, Vipul Datta, I give you this legal notice.
Yes.
Now here he says there's a hand note, you had taken 50,000, please return back the money. So under these circumstances, we said that you have misutilized those blank stamp papers, and that, which is why we were contesting the suit. Now, my lord, the plaintiff was cross-examined on this, my lord.
Yes,
Page 41, your lordship finds the cross-examination of PW1,
4-1.
4-1.
Yes,
Now, if I may read this, my lord.
yes.
The name of my son is Nirmal.
Hmm.
I have good relation with my son Nirmal. My son Nirmal used to remain as a tenant in respect of the suit premises. This is the first disclosure that his son was a tenant. After execution of the agreement to sale, I took possession of the suit premises on 29/7/2003. At the time of execution of the agreement, I consulted with my son Nirmal. My son Nirmal did not make any agreement with the defendant in the year 2002 for purchasing the suit premises. So this belies exhibit 4.
No, COI is for another agreement.
Yes. Yes, exactly.
This is not, this agreement is the agreement, which is the subject matter of the suit,
Is 2003, my lord.
2003.
And in exhibit my lord.
COI is with regard to 13 to 2002 agreement.
Exactly.
Some other agreement.
Some other agreement, my lord.
Yes.
Now, here he admits that my son did not have any agreement of 2002.
No, please read.
My son,
My son Nirmal did not make any agreement with the defendant in the year 2000 for purchasing the suit premises. He's
Correct.
saying of the suit premises.
Correct, my lord. Now, my lord, the agreement in question was written by the agreement in question was returned by the advocate's clerk in the court premises at Torney Hongo. In the court premises, I paid 2,20,000 to the defendant in presence of witness, D10. At the time of delivering the money, my son Nirmal was not present. He served advocate's notice on the defendant. I myself has given reply to given the notice to the defendant. The defendant did not give any reply. My advocate Sharma did not inform that he received any notice from the defendant. I have not gone through the written statement submitted by the defendant. The Horot and Pankaj, known to me, they were present at the time of execution of the agreement. We have called them to Torney Hongo. They also knew I have paid 2,20,000 to the defendant. There are about 6 rooms to the defendant, 6 rooms belonging to the defendant. Out of 6 rooms, other 4 rooms are in occupation of other tenants. 2 rooms are in my possession. There's a carpenter who has been occupying one of the rooms of the defendant prior to my agreement. He knew that the suit premises was delivered to me by the defendant. One Mintu is in occupation of one of the 2 of the rooms of the defendant. The said Mintu also knew that I took possession of the suit premises. I am ready to pay the balance consideration, and I have no objection if the defendant executed the sale deed as per the norms of the agreement in question. It is not a fact that I have obtained signatures of the defendant on blank papers. It is not a fact that I did not pay 2,20,000. It is not a fact that the amount of loan availed by the defendant was adjusted towards the advance consideration money paid by me. I do not know one Vipul Datta of Gopal Bazar. Vipul is not my relative. I know Vipul Patwari. He's not a relative. I do not know whether any notice was issued by my son Nirmal. Advocate D. Sharma received the notice of the defendant and he informed me about it. However, he did not read out the contents of the notice. It is a fact that my son and myself it is not a fact that my son and myself out of a conspiracy got the agreement in question executed by the defendant. I do not know whether the defendant has instituted a suit against my son demanding house rent and eviction. I do not know the agreement period. As per the agreement entered in by the defendant and my son, out of the land shown in the agreement, there were about 16 lechas of vacant land, and on that I constructed Charlie houses over it. It is not a fact that the possession of the suit premises was not delivered to me by the defendant. Now, my lord, if your lordship comes to the judgment now, my lord,
Yes.
of the trial court, at page 20 before that, if you're page 17, the judgment starts, my lord.
Yes.
Now at issue number 3 and 5, page 20, my lord. I'll
What is
read
the,
from,
what is the date of the judgment? 6 July,
yes,
6/7/2000 and 2000, 2007
yes,
or 8,
6
2007.
July 2008, my lord.
No, 7.
6/7, 2007, yes, yes.
By whom?
By the civil judge, senior division.
No, not senior. Civil judge.
Civil judge, Nalbari, my
Civil
lord.
judge.
The appeal was tried by the district judge.
Okay. Yes. At
Page 20, my lord.
20.
20. Issues are at page 18, my lord. And page 20, issue number 2 concerns whether there was 2,20,000 in pursuance of the agreement pursuit. The plaintiff has PW1 deposed that he has handed over rupees 2,20,000 out of the agreed amount of rupees 3,40,000. The defendant admitted in other way that 70,000 was handed over to him for execution of the agreement for sale of the land. Rupees 1,20,000 was handed over on earlier 3 occasions, which also carried an interest of rupees 30,000. Thus, in total, plaintiff owes 2,20,000 as had been paid to the defendant. Thus, I find and hold that this issue in affirmative in favor of the plaintiff. Issue number 3 and 5, my lord, this concerned whether he's entitled to specific performance and to what relief. From the above discussion held as above, as the vital issue number 2 was decided in favor of the plaintiff, I find and hold that the plaintiff is entitled to the decree for specific performance of the agreement for sale of the scheduled land. Plaintiff is also directed with a condition to hand over the 3 signed stamp papers to the defendant. These 2 issues are decided accordingly in favor of the plaintiff. In case of failure of the defendant to do so, the necessary deed may be executed and registered according to the provisions of Order 21, Rule 34. So, my lord, given my stand in the written statement, my lord, the judgment basically said that the stamp papers are required to be returned, my lord.
Yes.
Now, my lord, this was as per the stand taken in the written statement, my lord. Our only plea at this stage, my lord, since the court has directed return of the stamp papers, my lord, it is established that they had taken illegal custody of those blank stamp papers, and the blank stamp papers, as is apparent from the notices, my lord, were utilized, my lord, which is why the trial court ordered a return of the stamp papers, my lord. Our only ground is, my lord, given this situation, that the conduct of the plaintiff has come to the fore, my lord. Should the court not have accepted, because this is pre-amendment under the Specific Relief Act, prior to the amendment of 2018, my lord. And now specific performance has become mandatory once the agreement is proved, my lord. As per the old Act Section 20, there was a discretion cast. Now, given the conduct, since 20C concerns equitable relief, my lord, given the conduct that the blank stamp papers were eventually held in other way to be in custody of the plaintiffs, my lord, should the courts have not gone into the aspect of discretion under Section 20, notwithstanding my stand in the written statement? If I may read Section 20, my lord.
Was there any counterclaim?
No, there was no counter. There was no counter.
Then it is not a part of the decree.
It is not a part of the decree.
The observations to return the stamp paper, these are not part of the decree.
But if your lordship takes page 21, my lord.
Yes. Yes.
The last portion, the plaintiff will take all initiative within 2 months of time. So
Yes.
it's made a conditional decree. Now, my lord, if
What is the initiative? Initiative
No.
Initiative
to
is-
pay the balance consideration.
initiative is also to take reports of Order 21, Rule 34.
And also to pay the balance consideration.
That is,
My lord. Now, my lord, if that part is
see,
not-
Mr. Decker, you have also pointed out your inherent admission or lacuna, what, no, not say lacuna, the admissions made in the written statement itself, that you are ready and willing.
Alright.
You have not denied the agreement.
I'm
You have made in certain averments regarding monetary transaction, which in our opinion is not intrinsically connected with a defense which we might have taken in a suit for this performance. You have not denied the agreement, number one.
we've not denied it.
You have not raised any legal point of limitation or any otherwise. Everything is in terms of law.
My lord.
Your scope is very limited.
I agree, my lord. Only
Very
point we
limited.
are trying to emphasize on is
You are in a possession, Mr.
Yes. 2 room,
You are in possession of the suit property.
he's in possession of 2 rooms.
2 rooms means along with 1 kotha 10 acres of land.
Land was with rooms also, 2 rooms.
That 2 rooms falls upon the 1 kotha 10 acres.
Okay. You are in possession of the land also?
Yes.
Okay.
My
Yes,
lord,
and
in
anything else?
the evidence, my lord, in the evidence, it has come out that there are other tenants, my lord, and they're occupying just 2 rooms. Now, the plain does not really seek a relief of recovery, my lord, or delivery of possession, my lord.
Oh, well.
If your lordship will take up the plain, my lord.
You see, what is the you come to page 31,
Three.
paragraph 1. 31. And handed over possession of the land with 2 rooms. That is the specific case
Yes.
My lord.
in paragraph 1,
My lord.
page 31.
But as I've just read out from page 42, my lord,
Hmm.
during the cross is admitted, my lord.
What?
Page 42, my lord.
Yes, what is the admission?
That there are other rooms in possession of others.
Other rooms there, those rooms do not have.
But that will be his headache.
Hmm.
If
Alright.
the other rooms are within the suit premises,
Alright.
that will be his headache, how he evicts them. But he says, Mr. Chaudhary says that those rooms are not within this area of
Yes.
land, which is the subject matter of the suit. I think this was for 1 Katha 10 lecture.
1 kotha 10.
1 kotha 10 acres.
My lord, in the notice
With 2 rooms.
on behalf of the son, my lord,
Hmm.
that was also pertaining to the same, but the quantum is different.
It is not pertaining to the same, Mr. Decker. With Nirmal, the agreement was said to be 13/2/2002.
Correct,
This agreement is 29/7/2003.
correct, my lord.
So,
My lord, what has happened, my lord? Nirmal's, on behalf of Nirmal, he says that the agreement is of 2002 for the very suit property. And then, my lord, later on,
Nirmal was not the plaintiff. Nirmal, if he had come before the court, 2 suits were there, you might have had a case.
my lord,
Now, Nirmal is
my
not
lord,
even,
this is only
he is
to,
not even aggrieved.
my lord, this is only to show the conduct, my lord, because he said the advocate sends the notice saying
Your
that
conduct is okay. Had you taken a very positive stand of defense in the written statement. Written statement, you have admitted everything.
Right.
May not be a case.
And then in the cross-examination, my lord, plaintiff agrees that his son doesn't have any agreement of 2002.
No. You see, what is the agreement? Again, will be.
Page
come-
44 first, the notice.
No, come to 41. 41.
Yes,
We have to, again,
41.
41. The agreement in question was written so and so.
My son,
Yes.
my son did not.
At the time of execution of the agreement, I consulted my son Nirmal. My son Nirmal did not make any agreement with the defendant in the year for
2000.
purchasing the suit premises.
Yes. Now, your lordship will come to page 44.
So how does it make a difference?
Well, this goes to show the manipulation of the 44, my lord.
Yes.
This is on behalf of Nirmal. That on 13/2/2002
This is 1 Katha 5 Lecha.
of the same Dag and Patna, my lord. The suit property.
Nirmal chooses not to institute any case.
But his father admits that there was no agreement at the first place.
And Nirmal's notice is of the year 2023. He came in 2004. Yes, Mr. Chaudhary.
So the last point, my lord, appellate court did not form any point for determination and no discussion was there, though we had.
Everything has been admitted, my lord, and he is ready to execute a sale deed also, my lord. So here in this case, my lord, I think, my lord, I have nothing to submit more, my lord, in regard. And regarding evidence, my lord, the evidences are also clear, my lord. The execution of the agreement, that particular agreement for which this specific performance has been decreed, my lord,
No, Mr. Decca is trying to raise a point of equity. Because specific relief act, when you enforce, the question of equity will come. It's an equitable relief.
yes, ma'am.
There is no dispute on this aspect. Now, he says that from your own, from the records, from the materials available on record, it appears that there are monetary transactions. And even your son had issued a legal notice pertaining to another agreement.
There are more land, my lord, 1 Katha 10 letters. Maybe might be, my lord, for some.
No, he says it's 1 Katha 5 Lecha. It's a
1 Katha 5
land,
lecha.
land quantity is different, area is different, the quantity of the land. But Dag number is the same
Tag number same means, my lord, there are about 4 kathas of land.
in this Dag,
Put in that premises.
in this Dag.
In this Dag. In the, that appellant is owning, my lord, at present. And 1 Katha 10 lessons were agreed to sell to me, and this was handed over to me. This is the facts, my lord, in a written statement also it is admitted. So, my lord, the notice of 2002 and 2003, my lord, it doesn't come for adjudication in this case, my lord. And the appellate court also has finding with regard to that one.
You want to contend that covered by the same Dag number, there was the son's claim was for another plot.
Yes.
1 Katha 5
Maybe,
Lecha.
my lord. I am concerned with the 1 Katha 10 lessons along with 2 rooms. There are 4 other rooms, my lord. I am not claiming those.
That we have considered. Okay. Have a seat, please. The
No, will you, should I address my submissions on the revision, my lord, or will you not?
revision is for what?
Revision, my lord,
default of
we had instituted a separate suit against Nirmal because Nirmal was a tenant. He disclosed that only during evidence. And we got a decree of eviction against him. my lord. Now, that decree was affirmed by the first appellate court. Now, at the time of execution, they filed an application saying that we have a decree for specific performance, therefore you don't execute the decree. Now, initially, we approached the court saying that that decree of specific performance is in favor of Narayan. So far as Nirmal's possession over the suit premises is concerned, that is on the basis of a tenancy, and that tenancy having been determined, and the courts having held that he's a defaulter, he's liable to vacate, my lord. Subsequently, Narayan steps in by executing his own sale deed on the force of the decree in the
But,
other.
we have seen on the evidence that the plaintiff he admits that his son was staying as a
Correct,
tenant.
correct.
That has been. So what will happen to the fate of the revision?
Revision, my lord, that decree has to be executed.
Now your revision is for what? What are you?
For execution of that.
my lord, so far eviction is concerned, my lord, there is nothing, my lord. Because I've been handed over the position of the 2 rooms, my lord.
His father will evict him now.
And
Father has been
regarding
attorned.
other part, my
Father
lord,
has been attorned as the landlord now.
regarding
There has to be an assignment of the decree then, my lord. Because so today I have a decree affirmed, unchallenged, which says that Nirmal should be evicted. Malad. And that the executing court has to execute, Malad. It cannot go behind the decree and see whether there was another.
Even Nirmal is evicted, my lord, then also, my lord, that
Malad,
property
then
remains with-
it is for them to step in by executing the decree in this particular suit, provided they have a decree for delivery of possession.
regarding
No,
other.
they are already in possession.
Oh, Malad,
They are already in position, confirmation of position they are seeking.
Malad, then they'll have to find fault with the other judgment, with the eviction decree.
No,
which-
under the order which you are challenging in the revision, which what is the order?
There, the executing court said that we will execute the decree only after this specific relief. This RSA is disposed.
Can you really press upon that on practical purpose?
Alright.
You having come to the High Court or rather the aspect matter coming to the High Court after two courts and the decree, if we are going to dismiss your appeal,
Alright.
the decree is affirmed, then the decree will
But
pass
here
as
the
a landlord
Alright.
practically will not serve any purpose. Let us be very pragmatic,
Alright,
only for the sake of academic.
I understand, Malad, but only difficulty, Malad, though
No, you are going very technically.
though
You
it
may
may
have
seem very
you may have a point. You may have a point going very technically because that decree needs to be set aside by a competent court.
Yes, Malad.
But
And
whether
secondly, Malad,
whether the decree can be executable is executable at all.
Malad.
When your ownership has in the meantime your right over the land has been extinguished
Malad.
by a valid decree.
Malad, I agree, Malad. It may sound technical. The only issue is, Malad, the agreement is post 2002. Now, if it is post 2002, Malad, it requires registration in case possession is handed over on the basis of that agreement, Malad.
Which
Second,
agreement?
The agreement for sale. Where
In a second appeal.
Malad. Malad, I'm arguing for the CRP, Malad. And secondly, Malad, they have not claimed delivery of possession as yet, Malad.
CRP will only go by the orders which have been put to challenge.
Malad, very
We
good.
cannot go to the order with the decree passed in the other suit by them.
Malad, well,
Okay, please have your seat. The instant second appeal is preferred under section 100 of the Code of Civil Procedure 1908 against a judgment and decree dated 30/3/2013 passed by the learned district judge Nalbari in title appeal number 17 of 2007 upholding the dismissing the appeal and upholding the judgment and decree dated 6/7/2007 passed by the learned civil judge. Why do you get senior division?
the plain said senior division. Plains at page 30 said senior division.
Is it?
At that time,
Yes,
he-
yes. Oh,
That
okay.
time,
Yes,
no,
you're
no.
correct. No. Civil Judge Senior Division, Nalbari, in title suit number
34 of 2004.
34 of 2004. Full stop. The appellant was the defendant in the suit which was instituted for specific performance of a contract. Full stop. Para. The projected case in the plaint was that an agreement was entered into by the plaintiff with the defendant dated 29/7/2003 for sale of 1 Katha 10 lechas of land with 2 rooms, full stop. As per the agreement, comma, the total consideration was rupees 3,40,000, out of which the plaintiff had paid an amount of rupees 2,20,000, and delivery of possession was, and the possession of the suit premises was already with the plaintiff, full stop. It is also stated that the son of the plaintiff was a tenant in the suit premises, full stop. The defendants, the appellant defendant had filed the written statement in which a defense was stated that owing to owing to certain monetary transactions, comma, the plaintiff were in custody of 3 signed stamp papers, full stop. It was, however, admitted that the defendant, appellant defendant, was ready and willing to perform, to discharge his part of the agreement, provided the 3 stamp papers are returned to him, full stop. The learned trial court, after consideration of the facts and circumstances and considering the materials on record and the evidence of the parties, had decreed the suit, which was also affirmed by the first appellate court. Full stop. I have heard Sri B.D. Dekar, learned counsel for the appellant, whereas your 2 appellants are one. Appellant, whereas the respondent is represented by Sri Chaudhary, D. Chaudhary, learned counsel, full stop. The LCR, which have been requisitioned, have also been perused, full stop. Sri Dekar, the learned counsel for the appellant, has submitted that prior to the legal notice issued on behalf of the petitioner on 2004, comma, a similar legal notice was also issued on behalf of the son of the plaintiff, namely Nirmal Talukdar, pertaining to an agreement dated 13/2/2002, full stop. The learned counsel has also referred to another legal notice issued by the same advocate on behalf of another individual, Sri Bipul Datta, making certain claims, full stop. It is contended that all the aforesaid 3 legal notices clearly are based on the stamp papers which were in the custody of the plaintiff, owing to certain monetary transaction, as mentioned above, full stop. It is submitted that the relief claimed under the Specific Relief Act is an equitable relief, wherein the conduct of the plaintiff is of immense importance, full stop. In the instant case, the conduct of the plaintiff being doubtful, the learned courts below ought not to have passed the impugned judgments declaring the suit, full stop. Para. Sri Decca has, however, fairly submitted that in the written statement, there is an admission regarding the willingness and readiness of the defendant to discharge his obligation as per the agreement dated 29/7/2003, which, however, is qualified by the condition that the three signed stamp paper are to be returned to the plaintiff, to the defendant. Full stop. Para. It is submitted that the aforesaid aspects were, and it is submitted that while discussing issues numbers 3 and 5, though the learned court had made an observation regarding the requirement to return the stamp papers, the said aspect was lost sight of while declaring the suit. Full stop. The learned counsel accordingly submits that intervention by this court is required. Full stop. I have heard about. This court, wide the order dated 29/8/2013, had formulated the following substantial questions of law. That's what I have heard about. Para. Per contra, Sri Chaudhary, the learned counsel for the respondent, has submitted that the legal notice dated 10/6/2003 issued on behalf of his son Nirmal Talukdar is for a different piece of land which may be covered by the same DAG number. Full stop. It is submitted that the present suit was on the subject matter of an agreement dated 29/7/2003, in connection with which the legal notice was issued on his behalf on 27/2/2004, and therefore the said issue would not be relevant for the adjudication of the present lease alliance. Full stop. It is submitted that the defendant, having clearly admitted in the written statement regarding the basic facts and also expressing his readiness and willingness to discharge his obligation under the agreement dated 29/7/2003, no fault can be attributed to the decree passed by the trial court, which has been affirmed by the first appellate court. Full stop. It is submitted that there is no manner of doubt that the suit property, including the 2 rooms, were already in the possession of the plaintiff, and in the plaint and in the evidence, comma, there was a clear statement that the son of the plaintiff, Nirmal Talukdar, was in possession of the 2 rooms and the land as tenant. Full stop. Para. The rival submissions have been duly considered. Para. It is no doubt correct to contend that the rights exercised under the specific relief act, that the relief, no, rights, no, that the reliefs under the specific relief act is in the nature of equitable relief, and therefore the conduct of the party approaching the court for any such relief is to be free from any malafide. Full stop. However, comma, in the instant case, the apart from making a defense, however, in the instant case, comma, apart from making an averment that a similar legal notice was issued on 10/6/2003 on behalf of the son of the plaintiff, and another legal notice on behalf of another individual, Vipul Datta, comma, no substantial materials have been able to be brought to light to question the conduct of the plaintiff. Full stop. This court has noticed that while the legal notice pertaining to the suit was issued on 27/2/2004, which pertains to the agreement dated 29/7/2003, comma, the legal notice issued on behalf of the son of the plaintiff, Nirmal Talukdar, was prior in point of time, that is 10/6/2003, and the agreement is dated 13/2/2002, which is a different agreement. Full stop. Though it appears that the description of the property is over the same dug, comma, this court has examined for the sake of, examined in the interest of justice, and has found that the area of land is different. Full stop. Para. Sri Chaudhary, the learned counsel for the respondent, has also clarified that under the said dug, comma, there is a total area of
About 4 kathas of land.
a total area of about 4 kathas.
As
of-
informed me, Bharat.
4 kathas of land.
Because record does-
And the suit property and the suit land constitutes only 1 katha 10 lecha. Full stop. The what is also noticeable in this case is certain admissions made in the written statement. Full stop. A written statement, and a defendant in his written statement is expected to make all defense while contesting a suit, and the pleadings made therein would have a significant relevance in the adjudication of the lease. Full stop. In the instant case, comma, in paragraph, in the written statement so filed, comma, in paragraph 11, there is a clear admission that the defendant was willing and ready to execute the sale deed. Full stop. Para. For ready reference, comma, the said averments is extracted herein below. Page 37, paragraph 11. Averments of the written statement is extracted herein below. Para. The petition, the appellant has contended that as a corollary, and the contended that the aforesaid statement was qualified with a condition of returning the stamp papers to the defendant. Full stop. Though an observation has been made while deciding issues numbers 3 and 5 for return of such stamp paper, comma, in absence of, this court is of the view that in absence of a counterclaim on the issue, comma, the decree so passed cannot encompass the aforesaid observation. Full stop. Para. In para. This court is of the considered opinion that the plaintiff was able to make out a case for grant of a decree for specific performance with regard to the agreement dated 29/7/2003, and accordingly the impugned judgment of the first appellate court, by which the judgment of the trial court was affirmed, does not call for any interference. Full stop. Para. As a consequence thereof, comma, the substantial questions of law framed by this court in the order dated 29/8/2013 are decided against the appellant, and the appeal is accordingly dismissed. You write in the CRP, huh?
My lord, in the CRP, my lord, perhaps page 58, if your lordship takes up, no orders would be necessary because the executing court had deferred decision only until disposal.
Okay.
Now that the disposal has happened,
Well,
the
we'll close this.
executing court will see, my lord, decide.
No.
Page 58, my lord.
Partially, it has become infructuous after this.
58.
The last paragraph, in view of the above, I am of the considered opinion that it will be just and proper to stay the execution proceeding till disposal of the second appeal. Now the second appeal has been disposed of, the executing court will take whatever decision it has to.
Not close this. Why do you put a tail again?
My lord, possession
What do you get? What do you gain? Matters are to be concluded.
True, my lord, but execution discharge satisfaction that the executing court will decide.
Dispose will say this. Heard. Sri Decca BD Decca Learned Counsel for the petitioner, who by means of this petition filed under 227 or 115, filed under section 115 of the CPC. How do you read it? Of the CPC has put to challenge an order dated 11/9/2014 passed by the learned Munsif number 1 Nalbari in title execution case number 1 of 2012, staying the execution proceedings. Full stop. Para. Also heard Sri D. Chaudhary, learned counsel for the respondents. Full stop. Para. The learned counsel for the petitioner has submitted that the decree in question was for ejectment of the tenant who has been arrayed as respondent number 1. Nirmal?
Yeah.
In this present case, full stop. It is submitted that such decree for ejectment has been affirmed by the appellate court and thereafter was put to execution. Full stop. Para 3. Chaudhary, the learned counsel for the respondents, has however submitted that so far as the suit property is concerned, comma, that was the subject matter of another suit instituted by the present respondent number 2 for specific performance of an agreement dated 29/7/2003, which was registered as TS number 34 of 2004. Full stop. The suit was decreed, which was also affirmed by the first appellate court. Full stop. The petitioner herein had filed RSA number 168 of 2013, which however has been dismissed today. Full stop. Para. It appears that the grievance of the present petitioner was with the observation to keep the execution case in abeyance till the disposal of the second appeal, namely RSA 168 of 2013. Full stop. Para. This court is of the opinion that since the second appeal has been dismissed and the decree passed by the learned trial court, which was upheld by the first appellate court in title suit number 34 of 2004, has been affirmed by dismissal of the second appeal, comma, no practical purpose would be served by proceeding with the execution as accordingly the revision is dismissed. Full stop. The fact of dismissal of the RSA 168 of 2013 may be brought to the notice of the learned executing court for passing appropriate orders.
Much.
Your correct execution is not under challenge.
Not understanding the decree. Right.
I think 690.
Lordship, I'm submitting on behalf of Mr. S.K. Ghosh.
Yes.
Due to some miscommunication, Your Lordship, he missed the item, Your Lordship. I'm praying for
Miscommunication missed the item.
I'm praying for list the matter day after tomorrow.
What is the miscommunication?
I got the telephonic
Who?
instruction.
Who will communicate to him? His name is appearing.
SK called me, Lordship. He missed the item, Lordship. So
Oh, he missed the item. This is
yes,
not miscommunication. This is misreading.
missed it.
Communicate means somebody has to communicate. He did not read the cause list. Item number
6, Your Lordship. Praying for day after tomorrow, Your Lord.
2012 matter. Day after tomorrow, both matter fixed sources. Next Tuesday. Next Tuesday, is it okay, madam?
18, Lordship, after 8. So can
Day after tomorrow, we'll try.
21st, Lordship.
Day after tomorrow, we'll try.
Yes,
If it
Lordship.
reaches. But this week, as you have told, we have to rise early in the second half. So we'll try. 3 o'clock these 3 days. There's some interview administrative work.
Lordship.
Okay. We'll try. A prayer for adjournment has been made on behalf of Sri S.K. Ghosh Learned Counsel for the appellant. Para, Ms. R. Chaudhary, Learned Counsel, is present for the respondent number 2. Para, considering that the appeal is of the year 2012, comma, a short accommodation is granted, directing listing of this matter on 13th. Yes. 10 and 11. Review.
Yes, your lord.
Review of this court.
No, your lordship.
Yes, please. It is order dated 4/3. At least 10, my lord will find.
Yes.
4/3/15.
Justice PK Secretary.
Justice Speaker.
410.
4/3/2015. Page 10.
Who's seeking review? You are seeking insurance
Yes, my
company.
lord. Yes, no, my lord.
In item 11,
11
we are.
insurance company.
Both of you are seeking.
Yes,
Yes,
my lord.
your lord.
So far, my lord, item 11 is concerned. I concede to that because in the salary which was taken into account, that was inclusive of the GF and pension. So there is no dispute to that.
Oh, GF
Amount-
is different. Pension is different.
No,
Okay.
that salary is inclusive.
Okay.
So the learned court, what has done that it has increased by rupees 835.
Yeah.
So that was inclusive of the amount salary was taken into account. That was inclusive. So there was no need for further addition at 35 amount. So to that, his
What is your claim?
my claim is your lordship that if your lordship will kindly see at page 16, para 19, the age of the deceased was not for the purpose of multiplier. The age of the deceased was not taken into account. The age of the parents was taken, which is against the principle of law. So on that ground and further, my lord, on the date of the passing of the
It
original.
has been clarified that the victim is has to be reckoned from the person who has suffered, not the claimants.
Yes, your lordship. But at the time of appeal, your lordship, these terms were not agitated.
Doesn't matter. These are settled. These are principles of law, and these are all beneficial legislations.
Yes, my lord. That thereafter.
So far as age is concerned, it's it's not like.
There is no dispute as to age. The appropriate multiplier will be 18. That apart, your lordship, on the date of the passing of the original order, imperial order, the Sarla Burma's judgment was in existence. That guideline was there. Future prospect was not taken into account. I am not asking that if I am entitled for rupees 7,000, I am not asking that if it has been taken into account rupees 6,000 in absence of the appeal by the claimant, I cannot get it enhanced for 7,000.
Correct.
But the principle of law as regard to the non-conventional heads like funeral expenses consortium or the future prospect or the appropriate.
No, those are not subject matters of reviews.
My lord, no, that if your lordship permits me, may I?
You are seeking review only on the aspect of
multiplier and
age,
future
age.
prospect. If your lordship kindly take into account the judgment of this honorable court pass.
No, see, things which were not discussed, how can it be matters of review?
That was put.
One wrong appreciation which is apparent on the face of it.
That was
Suppose the
argued.
date, the age at the time, age of the victim. That is the wrong appreciation or incorrect or apparent on the face of it. That can be matters of review. But something which was that was difficult.
By virtue of section 168 of the MV Act, even in absence of any plea, if the court finds that yes, the claimant is entitled for this much of amount, that can be enhanced even in absence of any plea. So even in absence of the plea, not in the claim petition, in the absence of the plea, not taking before the appellate court also.
See where this
I will
review has to be examined from the point of view what was the law now. Today, as of today, if you argue, there are many more benefits you'll get.
I am not arguing.
No, today if you argue a claim petition of this nature, you may be entitled to many other benefits.
No, your lordship,
But
kindly permit me.
we'll go back. We
I
have to go
understand, my
back.
lord. I am not urging or putting any plea that what is available today. I am just bringing on record
what do you
that
say?
what was applicable at
What do you
the
say?
relevant time.
No, if you say that it's you are entitled under the law. Yes, what do you say?
Your lordship, they did not agitate this point.
It was
at the time
agitated
of
but not taken care of.
appeal, but only that age part can be rectified.
How much difference will it make?
It will not make much difference, my lord.
How much?
Future prospect judgment.
Now we know the future perspectives.
The future generally.
Yes.
we are 30. So
How much, no, that, you show us the Supreme Court judgment. Why are you showing this? There are Supreme Court judgments directly
yes,
on this.
but Bernard said that I have not put it. That was taken into on basing
No,
upon
no,
that.
how much difference will it make?
Just a minute.
Have you made the calculation?
Yes, my lord. Sorry. So if we take, let's say, multiplier of 18 and the annual income 3015 into 12, it will come 7,76,240. Whereas in the judgment under review, an award of rupees 6 lakh
698.
and odd.
698.
Yes, my lord.
And what about the
698.
the review by the, have you deducted that amount?
Yes, I have taken into account that after making that adjustment.
Okay.
The actual salary.
You make the calculation, you allow both the review. Make the calculation, both of you. Okay? And
Okay, Your Honor.
It's-
Lord, the only thing is that the.
you do one
multiplier
thing,
will be-
Mr. Jalan, Mr. Uttar, both of you sit together and you make the calculation, give it to him. Future prospectus, that's a part of, and also indicate the part where your review is to be allowed. We'll do the calculation and put it in. Okay.
Problem.
We'll allow both the review, but we'll do it today itself.
Yeah,
Give it
okay.
at before 2 o'clock. Okay.
Okay.
Hello, हो जाएगा. Boom.
I kindly passport and for the time being, use the like put number 80.
Okay, we'll try at 2 o'clock.
Lordship.
Huh? We cannot assure because we'll see hardly for 1 hour,
Yeah,
1 hour 15 minutes.
Lordship may fix another date.
Let us see how much there is one matter fixed.
Lordship.
Let us see. These are old matters, 15 matters.
Lord, either 13 also I have.
Hmm? 13 who's there?
Lordship, your Lordship has already partnered this matter.
13.
Yes.
Why? Eddie Chaudhary. Okay. Where is Mr. Chaudhary?
Lordship, he will come at 2. His junior to me, Lordship.
Oh, that matter.
Lord.
Okay, that was partnered.
Yes.
Okay, next. CRP 14. Ready? 5 minutes, you cannot be ready. You come at 2 o'clock.
Two. All right.
Mr. Deka, what is this?
My lord, this is a.
Where is Mr. Upadhyay? Upadhyay was around, we saw him. What is this matter?
My lord, the decree of eviction has been passed against me, my lord. You've
You're a
come-
tenant.
I'm the tenant,
Okay. Concurrent.
my lord.
Concurrent.
Concurrent, my lord. But I have a case, my lord. In fact, landlord tenancy was not, relationship was not proved in my.
Did you take it up as a defense in your written
Yes,
statement?
yes.
That he is not your
In fact, my
landlord?
lord, there were 2 rounds. First round, my lord, this is all government property, my lord. He says that I constructed a room and I let it out to
Mr. Upadhyay?
My lord.
You're on government property.
Government property, we are in occupation of temple last several years. So government property, my lord, but he's a tenant. He's a tenant.
You're also a tenant
No, I'm not a tenant.
of the government.
Your minor is. Suit was dismissed. Suit was dismissed. On the
Suit
ground.
for ejectment on the ground of what? Defaulter?
Default.
No, Mr. Deka is raising a preliminary issue that he's denying your, the tenancy, the relationship of landlord and tenant. What is the finding on this aspect?
Finding minute.
Was the issue framed on this?
No, I'll just quickly point. out.
We'll have to
With-
come back.
Yeah.
I don't know how. But you know how it is. So which matter will it take at about 2 o'clock? Three matters are there. Draw of lots. Draw of lots. Mr. Jalan, give the, okay.
My lord, the suit, file on 93, my lord. Your lordship may see page 5.
Just a minute, please. Appellant is the,
Appellant is the, my lord, the power of attorney holder
no,
of the
no,
land.
plaintiff for the defendant.
Is a defendant number one.
Appellant is one appellant.
One appellant,
Is a defendant number one.
one, my lord.
Suit for,
Suit for, my lord, recovery and cast possession, my lord, of the food land.
not for declaration.
Declaration and recovery of cast possession.
Declaration of right and interest.
Yes, my lord.
And recovery,
Opposition, my lord.
cash position.
Cast possession.
Okay. What was the projected case?
My lord, the projected case is that, my lord, the plaintiff, my lord, he has.
The suit has been declared by both the courts.
Both the court, my lord.
Okay.
I'm on the reverse side, my lord, my lord. And it was filed in 2008, my lord,
Suit was instituted in 2008,
2008, my lord.
not 2000. RSC is 2008.
Second
RSC
Second appeal is 2008.
2008. Suit
Second
is of 1997, you said.
Yes, yes.
Suit of 1993.
93, 46 of 1993.
1993.
The suit was filed on 25/8/19.
You are still to get the fruits of your decree, Mr. Sheikh. You are still to get the fruits of the decree.
Well, the issue is very short matter.
Just a minute, please. Title suit of 46 of 93.
46 of 93, my lord. At 25/8/93, my lord, the petition was filed, my lord, the plaint has been filed.
Okay, what was the projection in the plaint?
My plaint, my lord, that plaintiff is the owner of 10 biga, 2 kata, 5.5 lakhs of land, my lord.
Owner of
10 biga, 2 kata, 5.5 lakhs of land,
2 kata 5.5 lechas.
my lord.
Where?
This is my lord.
Nagaon.
No, Kolyapur, Nagaon, my lord.
Okay. Okay, Nagaon.
Nagaon, my lord.
Then what had happened?
My lord, he had executed a power of attorney, my lord, on 10/3/80.
Plaintiff.
Plaintiff, 10/3/80.
10
380.
80.
Yes, 10/3/1980.
Okay, power of attorney by
by
Plaintiff,
him to defendant number one, my lord.
to defend
That
number
is
one,
we, my lord.
yes.
So
For-
why he's given that land for, my lord, because his case is that, my lord, he was in the government job, he was outside, my lord, and then he has to look after the land, he has given power of attorney to the defendant
To
number
look
one.
after the land.
Yes, ma'am. And thereafter, my lord, on 9/8/91, the power of attorney got cancelled, my lord. 9/8/91
Was cancelled.
cancelled, ma'am.
Okay, then what happened?
Then, my lord, there was a criminal proceeding 145 under 145 CRPC, my lord. And in that,
Who had instituted
the plaintiff, my lord,
145 proceeding?
proceedings, my lord. Those proceedings, my lord, went against him, my lord, subject to filing of a civil suit for recovery of the land.
Correction. Okay.
Then, my lord, he filed a suit, my lord, 93, my lord, and that suit had decreed in his favor, my lord.
Now, what
Then-
was the subject matter?
Subject matter is that, the power of attorney, my lord, that power of attorney which is
You said
executed.
you had cancelled in the year 1991. Then-
91. So then, my lord, he has asked for the land back to him, my lord. So he has not
Oh, on the strength of the power of attorney, the defendant number one was possessing the land.
possessor.
He wanted a recovery of possession.
Yes, ma'am.
On the cancellation of the power of attorney.
In view of the cancellation of it.
That was the cause of action.
That is a cause. So he is holding the land on the basis of the power of attorney, ma'am. Of course,
Now, what is your defense?
defense is that, my lord, I have said that, my lord, that power of attorney, which I have no knowledge about the cancellation of the power of attorney.
Now you have knowledge.
No, I have knowledge.
At least on institution of the suit or filing of the 145, you know that the power of attorney was cancelled.
Yes, sir. Now I have definitely the knowledge. But well, sometimes I think by the 2008, by the filed the case.
But when the power of attorney is cancelled, can you force yourself to be, no, I want to be your power attorney?
And that person died also by the meantime.
Who?
Lucky, and that's the person who has given me power of attorney.
The defendant number one passed away.
Passed away.
What is there to decide? See, power of attorney is essentially
fact,
limited. It is not, it will not get transferred to your successors or
Yes.
your legal heirs.
And in between, my lord, petition, the respondent number one died, my lord. Then respondent number three also died, my lord.
They are the plaintiffs.
They're the plaintiffs, my lord.
How many plaintiffs are there?
My lord?
The suit was instituted by how many plaintiffs?
Initially, my lord, only Lakhirani Das has filed the suit. He was there, my lord. Lakhi Chandra Das.
Then he passed away.
And then he passed away, then his legal heir had come into, my lord. Lavanya Das,
Original.
numbering 10, my
The
lord.
plaintiff was Lakhi Ranjan.
Lakhi Chandra Das. Lakhi
And-
Chandra Das.
He died. And
Died,
then
my
now
lord.
how many? The legal heirs, how many?
10, my lord. And
10.
out of that, my lord, one and three died, my lord.
Right. Okay. Okay. You are yet to get possession of the land. The original plaintiff did not get his in his lifetime. If everything goes on well, this will come to an end today.
Yes, this will come to end today.
We do not know what is going to happen next minute, but still.
I think,
Mr. Sharma is smiling behind
21 years.
with his vast experience in civil field. Mr. Sharma, can you narrate something to him?
We discussed my lord before he came.
When the son and the grandson had become a lawyer and the suit was.
I was not in that suit, my lord. Otherwise, recovery of the adverse possession right also we can claim, my lord. But that was never been claimed, my lord, adverse possession.
No, Mr. Sharma on a lighter vein was narrating something. Son had become a lawyer. He came back.
Oh,
That matter is over. Which matter? That matter. Oh my God, what have you done?
uh,
Okay, what is the defense?
that is, my lord. Defense is that, my lord. I have no knowledge of the power of attorney.
Till when?
Till filing of the suit, my lord. If a
Then
lordship,
after that,
lordship,
let us assume that this is correct. You don't have the knowledge.
yes. After that, of course, my lord, I have the knowledge, my lord.
Now, after that, what is the
Yes,
strength of
yes.
your, what would the
That lordship
holding of
is
possession, which
the
will be on the
first-
strength of what?
The WS, my lord, lordship may see at page 17, my lord.
17.
17, my lord. Lordship may see para 11, third parameter, as the valuation of the land,
Yes, para 11.
11, my lord.
Yes, third para. True.
As the valuation of land was increased day by day by the plaintiff with a view to avoiding the sale agreement of the sale executed a so-called deed of cancellation of power of attorney without the knowledge of the defendant. So this is only plea he has.
Was there an agreement for sale?
There was, my lord,
But
but
he did not file for any specific performance.
that was for agreement for sale only, but no.
Even assuming there was an agreement for sale, unless you file an independent suit or a counterclaim for
Yes.
such execution.
Yes, there was no counterclaim
No
also.
counterclaim.
There was no contract.
But let us see the substantial questions.
Substantial question as framed, my lord, whether the issue number 5
Was it actually framed?
would be decided, yes. Court has framed it, my lord.
Issue number 5 could be decided in favor of the plaintiff.
Plaintiff by resorting with the provisions of section 207 of the Indian
No,
contract.
Indian contract. Act.
207, my lord. Revocation and reunification may be expressed or implied.
No, why is 207 necessary? Was it by
That is the court has came to the finding, it may be impliedly also, my lord.
no? Here there was an overt act of cancellation of the.
Yes.
So why is this required? at all?
That is not of, after all the district judge, there is a finding, my lord, that notices, I'll take it to lordship to that
Whether the issue number 5. What is issue number 5?
5. Lordship may come to page 41 of the appellate or court order, my lord. And issue number 5 where the court below.
Now, what was the issue number 5? Issues are where, Mr. Roy?
Issues are,
Issues are page 35, 35.
yeah, no, my lord,
35.
page 21, point number 5, my lord.
Same 35 also.
Yes.
Whether the power of attorney was cancelled.
Same 35, yes. So 5 is that whether the power of attorney was cancelled with the knowledge of the defendant number 1. Now the finding is, my lord, at page 41, my lord. Yes, to verify.
Page 41.
Page 41, man, issue number 5.
Yes.
The defendant number 1 appellant side has submitted that the power of attorney exhibit 2 was not cancelled and no notice was issued to the defendant number 1 either before or after the so-called cancellation of the deed by executing the registered deed of revocation cancellation of the general power of attorney. Exhibit 3, it has been further contended that it is settled principle of law that due notice of cancellation of a power of attorney must be given to the concerned attorney. The plaintiff side has contended that the original plaintiff Lucky Chandra Das, since this is cancelled or revoked the power of attorney, exhibit 2 dated 11/3/80 by executing a registered deed of cancellation, exhibit 3 dated 9/4/91 and duly communicated to the defendant number 1 registered notice, exhibit 10 dated 12/4/91 and demanded back the possession of the suit land. Section 206 of the Contract Act requires that reasonable notice must be given of such revocation of power of attorney to give effect or bind the agent or the third person when it becomes known to them as provided under section 208 of the Act. From the evidence of original plaintiff PW3 Lucky Chandra Das, it is evident that before revocation of power of attorney exhibit 3 conferred on defendant number 1, the latter was verbally informed to written notice, no written notice was given. This fact has come in the evidence of PW5, Shri Hiren Das, responded plaintiff number 3, who is one of the legal heir to the said this is original plaintiff PW3. According to him, the power of attorney exhibit 2 was revoked by the registered revocation deed exhibit 3, and the revocation or cancellation was duly communicated to the defendant number 1 by registered letter exhibit 10. The revocation or cancellation was effected when his father learned that the defendant number 1 was negotiating to enter into an agreement with defendant number 1 to sell the seed land. He, however, could not confirm in a cross-examination that such notice was given to the defendant number 1, but stated that his father PW3 after retirement from service informed the defendant number 1 or his intention to reside in the suit land. The defendant number 1, Hira Das, denied in evidence on affidavit to have received the notice of revocation of power of attorney exhibit 3. The cross-examination, however, reveals that he did not learn the revocation or cancellation of the power of attorney, and if the same was ever communicated to him. Section 206 of the Contract Act reads as follows: notice of revocation or renunciation, reasonable notice must be given of
Mr. Roy, you may be correct in contending that the materials to come to the conclusion were not enough. But will that be the entire position? Because there is no materials to show that he was ever put to notice. And the notice was sent after cancellation, which perhaps will not meet the requirement 206. 206 talks about notice of revocation or renunciation. And 207 is only on the aspect of revocation and renunciation, which can be expressed. But the notice is contemplated by 206. This discussion perhaps may not be directly connected with 207. It is not a question of how we have revoked. It can be implied or expressed.
The knowledge, man.
Knowledge. Have you given notice before revoking?
Yes, that is correct.
That was the issue.
That.
But the power of attorney holder has also passed away.
That is correct.
The original executor has also passed away. Nothing remains actually. Yes. Anything? You are reading the trial court judgment. Yes, no?
That's
appellate first. Yes, dealt with all the aspects, but the discussions and findings are not connected. Had it been some other case, matter would have been slightly different. Mr. Sheikh, have you noticed that? You don't bring in 207, that is not even the issue. 207 says that the revocation can be implied or expressed. That is not the issue. Issue was whether you were given notice prior to the revocation. Revocation as such is not the disputed matter. It has been revoked. But the dispute is whether before revoking, you had issued notice. Materials are that after revocation, you had issued the notice. That is not enough actually. Going strictly by the law, but by the developments. Okay.
But the only thing is this, my lord, for 23 years, my lord, my planted friend enjoyed this property by this litigation.
The final finding is at page 44, my lord.
Okay. The present appeal is preferred under section 100 of the Code of Civil Procedure, challenging a judgment and decree dated 19/5/2008 passed by the learned Additional District Judge Nagaon in title appeal number 10 of 2006, whereby the said appeal was dismissed. Full stop. The first appellate court had accordingly affirmed the judgment and decree dated judgment and decree dated, is it 27 March 2006?
27/3/2006.
2006, passed by the learned civil judge within bracket senior division bracket close Nagaon in title suit 46 of 1993. Full stop. The appellant herein was the defendant number one in the title suit. The defendant number one is still there.
He's there.
The suit was instituted for declaration of right, title, and interest and recovery of caste possession. Full stop. Para. The projected case in the plaint was that in the year on 10/3/1980, a power of attorney was executed by the plaintiff in favor of the defendant number one to look after the suit land, as the plaintiff was a government servant. Full stop. On 9/8/1991, the said power of attorney was cancelled, and the land in question, which was in the possession of the defendant number one, was demanded back. Full stop. Initially, the plaintiff had also instituted a proceeding under section 145 of the CRPC, in which, however, a direction was given for approaching the appropriate forum of law. Full stop. Consequently, title suit 43 of 1993 was instituted as mentioned above. Full stop. The trial court had decreed the title suit in favor of the plaintiff, and the said judgment and decree has also been upheld by the first appellate court by the impugned judgment dated 19/5/2008. Full stop. I've heard Sri J. Royal Senior Counsel for the appellant assisted by, what is your name?
BP Sharp.
BP Sharma, Learned Counsel. I have also heard Sri M.A. Sikh, Learned Counsel for
Respondents.
all the respondents.
Sorry.
All the respondents. Full stop. Para. Sri Roy, the Learned Senior Counsel, at the outset has informed this court that during the pendency of the case, comma, the original plaintiff, Lokhi Chandra Das, had passed away, and he was accordingly substituted by 10 numbers of legal heirs. Full stop. However, comma, out of those legal heirs, comma, the appellant number, the plaintiff number, he died during the pendency of the suit.
Yes.
Suit
Pendency-
or appeal.
No, after, I think after the judgment.
However, comma, two of the legal heirs, namely number 1 and number 3, had also passed away. Full stop. Para. The principal defense taken in the written statement by the present appellant as defendant was that he did not have any knowledge regarding the cancellation of the power of attorney. Full stop. By drawing the attention of this court to the written statement filed by the appellant in the suit, comma, the averments made in paragraph 11 have been relied upon. Full stop. It is contended that upon consideration of the rival pleadings, comma, issues were framed, and the relevant issue is issue number 5, which reads as follows, page 22, issue number 5. The learned counsel for the appellant has submitted that no, Tara would like before her hearing, I have heard her. This court wide order dated 28/11/2008 had framed the following substantial question of law. 28/11 quote করে দিবা. That's what I have heard. Continue করেছে বা. The learned senior counsel for the appellant has submitted that the recourse to section 207 of the Indian Contract Act 1972 1872 was not justified in the facts and circumstances of the case. So it is further submitted that the materials on record, including the evidence, would not be enough to establish that there was any notice issued for revocation of the concerned power of attorney dated 10-3-1980. Full stop. The learned senior counsel accordingly submits that the substantial question of law is to be decided in favor of the appellant, and accordingly this court should intervene with the impugned judgments and the suit should be dismissed. Full stop. Para. Per contra, Sri Sheikh, the learned counsel for the defendant, has submitted that the materials on record would show that the power of attorney, that the concerned power of attorney dated 10-3-1980 was cancelled on 9/8/1991 and therefore upon such cancellation, whatever right had accrued to the defendant had extinguished. Full stop. In any case, he submits that in any case, the said power of attorney was only restricted to look after the land, and on such cancellation, the land was supposed to be handed over back. Full stop. Para. On the aspect of notice before such revocation, he submits that there are materials on record that the defendant was indicated about such revocation as the original plaintiff, who was a government servant, was on the verge of his retirement. And after such retirement, he had expressed his desire to reside over the said plot of land by himself. Para. The learned counsel for the respondent has also submitted that recourse to Section 207 of the Indian Contract Act by the learned court was justified on the facts and circumstances of the case, as the suit was instituted only after the initial attempt by the plaintiff by instituting a proceeding under Section 145 of the CRPC had failed to get the desired results. Full stop. It is the learned counsel has also informed that the original plaintiff, who was the power of attorney, who was the executor of the power of attorney, had passed away, and therefore, for all practical purpose, the power of attorney has become redundant. Full stop. Para. The rival submissions have been duly considered, and the materials placed before this court have been examined. Full stop. Para. The learned court below has invoked the provisions of Section 207 of the Indian Contract Act 1872, which lays down that revocation and renunciation can be expressed or implied. Full stop. However, in the considered opinion of this court, the issue was not connected with the act of revocation of the power of attorney, of the instrument, but the requirement of notice prior to such revocation. Full stop. The defense taken in the written statement is lack of knowledge of such cancellation. Full stop. The perusal of the written statement would, however, show that the defense was not pertaining to non-receipt of notice as required, non-receipt of notice before such revocation. Full stop. The materials on record would show that the action of revocation was informed to the defendant by registered post with AD. Full stop. However, this said action may not amount to a prior notice for such revocation, which is a requirement of law. Full stop. However, this court has also noticed that there are materials on record to show that the original plaintiff had informed the defendant, number one, regarding his intention to possess the land by his own as he was on the verge of his retirement. Full stop. In the full stop para, this court has also taken note of the fact that the executor of the power of attorney, that is ISD, plaintiff, original plaintiff, has passed away in the meantime, and therefore the power of attorney has become redundant for all practical purposes. Full stop. Para, considering all the facts and circumstances, this court is of the opinion that the impugned judgment and decree passed by the learned First Appellate Court dated so and so, affirming the judgment and decree of the trial court in TS number 46 of 1923 does not require any interference. Full stop. The substantial question of law is accordingly answered against the appellant and in favor of the respondent. Full stop. Appeal accordingly stands dismissed. Para, send back the records. Okay.
Obliged. Item 12.
Appeal by the defendants.
Just a minute, please. Appellant is the defendant.
Yes. Lord. Husband and wife, Lordship, both the defendants.
Two appellants.
Yes, correct.
Suit for?
Suit for right title interest and recovery of possession.
Okay.
And the suit was-
concurrent finding.
Yes, Lordship. Concurrent finding, not concurrent, Lordship. The trial court decreed the suit partly. Right title was declared, recovery was not declared, Lordship. Recovery prayer was not granted by the learned trial court. So plaintiff preferred title appeal. We have not filed any cross appeal. Lordship. Plaintiff filed title appeal. First appellate court held that lordship, the right title is also there and recovery was also granted. Therefore, this present regular second appeal. And the second appeal was admitted on lordship 7/11/2015.
The second appeal would only be confined to the aspect of right title.
No, lordship, right title, recovery both.
The recovery has attained finality.
No, lordship, right title attained finality.
Or right title was attained
Attained
finality.
finality,
Or
but
you want
lordship,
the
there are
recovery
some
part.
decisions that even without filing cross appeal by the defendants, we can challenge the entire decree, lordship, even in absence of cross appeal. So I am challenging the entire decree, right title and lordship. I have given the list of books, but that is AIR 2007 SC 989. Para 7 and 8, lordship. And another one, AIR 1999 SC
Paragraph
357.
7 and
7
8.
and 8.
Please read.
Para 7, the High Court, in our view, was clearly in error in holding
Let us see
that
4133. Let us see 4133.
power of Court of Appeal. May I read?
Yes.
The appellate court shall have power to pass any decree and make any order which ought to have been passed or made, and to pass or make such further or other decree as or order as the case may require, and this power may be exercised by the court, notwithstanding that the appeal is as to part only of the decree and may be exercised in favor of all or any of the respondents or parties, although such respondents or parties may not have filed any appeal or object, and may, where there have been decrees in cross suits or where two or more decrees are passed in one suit, be exercised in respect of all or any of the decrees, although an appeal may not have been filed against such decrees, provided that the appellate court shall not make any order under section 35A in pursuance of any objection on which the court from whose decree the appeal is preferred has omitted or refused to make such order. So as per order 41 rule 33 also, I can challenge the entire decree, lordship. Though right title was declared lordship, it is a paper decree. It cannot be executable. There is no recovery prayer was granted to the plaintiff. And that decree is not affecting the defendants as they are also purchased by registered deed, lordship.
Let us suit for right title, interest, and recovery of possession.
Yes,
Trial court decreed
yes, lordship.
for right title.
Right title, lord.
No decree for recovery.
Yes, lordship. No decree for recovery, and there was no issue in regard to disposition also. And very interestingly, lordship, the
Then
issue,
appellate court, they preferred appeal.
yes,
Plaintiff
plaintiff
preferred
preferred appeal.
You did not prefer appeal.
No, lord.
Appellate court decreed the,
Affirmed and partly modified also, lordship. Decreed right title as well as recovery.
okay. Yes.
And disposition part was discussed in the lordship, the issue number 4 and 5. That was in regard to the relief prayer of the plaintiff, lordship. No separate issue in regard to disposition was lordship formulated by either by the trial court or by the first appellate court. Even first appellate court also held in discussing about disposition in relief issue number 4 and 5, that though it is required to file an issue, lordship, their argument is also that though it is necessary to frame an issue, but no issue was formulated, and in issue number 4 and 5 only disposition part was discussed, Lordship. And my substantial question of law is that, Lordship,
Yes,
whether the finding of fact recorded by the learned first appellate court in respect of issue number 3, 4, and 5 are perverse to the evidence on record. So this is the substantial question of law, trial court judgment, page 13. Lordship. Page 14, the issues, whether there is any cause of action for the suit, whether the suit is maintainable in the present form and manner, whether the plaintiff is entitled to
page.
page 14, Lordship. Only 5 issues.
Just a minute.
Whether there is cause of action for the suit, whether the suit is maintainable in the present form and manner, whether the plaintiff is entitled to declaration of right, title, and interest over the suit claim, whether the plaintiff is entitled to any relief prayed for, to what relief the parties are entitled. And plaintiff examined Exhibit 1 registered sale deed, that is his purchase deed. Exhibit 2 is the certified copy of Jamabandi. Exhibit 3 is the certified copy of Chita. And we have exhibited 3 registered sale deeds by which we have purchased our land. Lordship. So 1 and 2 I am not reading, Lordship. Page 15, issue number 3. Whether the plaintiff is entitled to declaration of right, title, interest over the suit claim.
Okay.
PW1 plaintiff Khairuddin Mondal has deposed in his evidence.
Page you are reading?
Page 15, Lordship.
Next
Issue
page.
number 3.
Next page.
Yes, sir.
Issue number 3.
Yes. PW1 plaintiff Khairuddin Mondal has deposed in his evidence that he purchased the suit land from one Ruma Chaudhary, daughter of Nipendra Narayan Chaudhary and Trivendra Narayan Chaudhary, son of late Nipendra Narayan Chaudhary, on 19/5/2007. So plaintiff's purchase is in the year 2007 by executing a registered sale deed number 566, that is Exhibit 1. And since then has been owning and possessing the suit land openly, continuously with the knowledge of the defendant. PW1 deposed that accordingly plaintiff's name was recorded in Jamabandi and Chita with respect to the suit land. PW1 exhibited the registered sale deed number 566 as Exhibit 1, the certified copy of Jamabandi and Chita as Exhibit 2 and 3 respectively. Upon perusal of the exhibits, it is seen that plaintiff through Exhibit 1 purchased the suit land covered by DAG number 42293 and Fatta number 32 from the sellers mentioned above, along with some other land in different DAG. In Exhibit 2 and 3, his name is mutated and recorded as Patradar. Exhibit 3 in the remarks column shows that plaintiff through Exhibit 1 has purchased the suit land, and accordingly in place of father of sellers, Ruma Chaudhary and Trivendra Narayan Chaudhary, Sri Nipendra Narayan Chaudhary, plaintiff's name is entered. In his cross-examination, there is nothing on record to.
Sale deed is Exhibit 1.
Yes, okay. His purchase deed.
19/5/2007.
566.
Huh?
That is deed number.
No, 19/5/2007.
19/5/2007.
Deed number 566.
566.
Okay.
In his cross-examination, there is nothing on record to presume the contrary of execution of the sale deed number 566. PW1 deposed that sellers were son and daughter of Patadar Nipendra Narayan Chaudhary. PW2 Abdul Malek corroborated the PW1's evidence and deposed that plaintiff did purchase the suit land through Exhibit 1 and since then was in possession of the suit land. PW2 deposed in his cross-examination that he saw the execution of Exhibit 1 by plaintiff and Roma Chaudhary and Trivendra Narayan Chaudhary. DW1 Hyder Ali deposed nothing about plaintiff's title in the suit land. DW1, however, deposed that defendant number 2 had purchased 2 Katha 11 letters in the dark number 93 and Patta number 32 through Exhibit A, B, and C, pre-registered sale deed, including the suit land, and after purchasing his lands was in possession of the same. Now DW2 Maleka Khatun, that is defendant number 2, deposed that she purchased 2 Katha 11 lesser land through Exhibit A, B, and C, which includes the suit land, and has been in possession of the purchased land, and that it includes the suit land. DW2 in her cross-examination denied knowledge about the total land in dark number 93 and Patta number 32. DW3 Dilwar Hussain deposed that defendant number 2 had through Exhibit A, B, and C purchased land measuring 2 Katha 11 lesser, including the suit land, and accordingly her name is entered in Revenue Record of Right. DW4 Surat Jamal deposed that defendant number 2 had through Exhibit A, B, C purchased land measuring.
This, madam, this Exhibit 1, sale deed of 566,
Yes.
which is the plaintiff document, and the exhibits A, B, and C of the defendants, 2 Katha 11 letters, this pertains to the same land.
There, the trial court held that this dark contains only 2 Katha, lordship, 2 Katha 16 lesser or something. So after deducting Exhibit B and C, there remains only 5.6 lesser, 6.5 lesser or something. So trial court held that the defendant through Exhibit A purchased 12.5 Katha. So her purchase cannot be believable as because there remains only 6.5 lesser land. So plaintiff's land is only 5 lesser, so that is believable. So right title of plaintiff was given.
The sale deeds otherwise were not interfered with.
No, Lord.
Of Exhibit 1 as well
There
as
was no prayer about cancellation of sale deed of ABC, Lord. And my Exhibit A is prior to Exhibit 1.
what was the amount, area of land under sale deed? 566?
5 lesser.
5 letters.
Yes.
By 2007, they had purchased 5
No,
letters.
Lordship, 10 lesser. 5 lesser in DAG number 93 and 5 lesser in some different DAG. That is not to play.
Total, just a minute, please.
Ten lesser. What?
Okay.
That was clearly stated by the first appellate court. I'll read that judgment, Lordship. That will become clear. Now, page 16, DW3 Dilwar Hussain deposed that defendant number 2 had through Exhibit A, B, and C purchased land measuring 2 Katha 11 lesser, including the suit land, and accordingly her name is entered in Revenue Record of Right. DW4 Surat Jamal deposed that defendant number 2 had through Exhibit A, B, and Exhibit C purchased land measuring 2 Katha 11 lesser, including the suit land, and accordingly her name is entered in Revenue Record of Rights. Upon consideration of the oral and documentary evidence of both sides, it is seen that Exhibit 2 and 3 shows the plaintiff to be a Pattadar in DAG number 93 and Patta number 32. The Exhibit 1 adduced by plaintiff is not denied by the defendants in their written statement or in evidence and shall be deemed to have been admitted. The PWs have, in a coherent and steady manner, deposed that plaintiff did purchase the suit land by executing the exhibit 1, and accordingly his name was entered in exhibit 2 and 3. Also, exhibit 2 and 3 shows both plaintiff and defendant number 2 to have purchased land through exhibit 1, B and C. And as a result of the deeds have individually obtained title over 5 lessas by plaintiff and 1 katha and 18.5 lessa by defendant number 2. Exhibit 3 shows both as pattadars. In absence of denial and any evidence to the contrary, the plaintiff is found to have purchased the suit land and thereby obtained title over the purchased land. So there was no effort by any of the parties to prove the registered sale deed. Lordship only exhibited the documents. And merely on presumption, Lordship,
But
trial
you have not denied the sale deed, you have not questioned the sale deed.
no, Lordship, in written statement, we have denied the entire para. And in para number 2, the plaintiff mentioned page 5, Lordship, that her purchase, she has mentioned in para number 2, and in written statement, we
What
have
did you
denied.
say?
Yes, Lordship, in written statement, white para number 6, we have denied, the defendants deny the contents of para number 2 of the plaint. So these facts are also perverse, Lordship, by the learned trial court. There is a denial by the defendants in their written statement. So thus plaintiff is found entitled to declaration of right title interest over the suit land. So right title of the plaintiff over 5 lessa was declared, and 1 katha 18.5 lessa of defendant was also Lordship admitted in the trial court judge. Only my exhibit A was not given Lordship consideration. Now, Lordship, the issue number 4 and 5, whether the plaintiff is entitled to any relief prayed for, to what relief the parties are entitled. In these issues, Lordship, in these two issues, the disposition part was discussed. PW1 has deposed in his evidence that he was dispossessed from the suit land by defendants in the second week of March 2012, when defendants came to the suit land by breaking the bamboo boundary wall of the suit land and threatened the plaintiff against any attempt to enter the suit land. PW2 deposed on similar lines and corroborated the evidence of PW1, but failed to mention in his cross-examination the date of disposition and stated that he heard about disposition and did not see it. PW1 in his cross-examination stated that the total land in Dag number 93 and Patta number 32 is 2 katha 5 lessa. So in Dag number 32, only 2 katha 5 lessa land is there, Lordship. This fact is not denied by defendants in their evidence. PW1 also admits the exhibit A, B, and exhibit C, but declined knowledge about the measurement of land purchased by defendant number 2. So PW also admitted my statement. DW1 in his evidence denied defendants having dispossessed the plaintiff from the suit land. DW1 rather claims that defendant number 2 purchased 2 katha 11 lessa of land, including suit land in 1996, and since then has been possessing the same. DW2 also denied the claim of disposition of plaintiff as false and vexatious. DW3 and 4 depose nothing about disposition of plaintiff by defendant. Thus, the disposition of the plaintiff by defendant is wrongly written, Lordship, is denied by defendant. PW1, although deposed about the disposition, PW2 deposed hearsay about the incident of disposition. The allegation of disposition is hence not proved. The plaintiff and defendant are pattadars of the same dag, which consist of 2 katha 5 lessa of land. Plaintiff is proved to have purchased 5 lessa through exhibit 1. Exhibit 3 shows the defendant purchased land measuring 1 katha 18.5 lessa. In the same dag, DWs, however, state that defendant number 2 purchased 2 katha 11 lessa of land. If the dag contains only 2 katha 5 lessas of land, defendant cannot buy land in the same dag more than what it comprises of. Thus, it is found that as per exhibit 3, which is the certified copy of a public document, proves that defendant number 2 purchased 1 katha 18.5 lessa. Now, thus, together plaintiff and defendant purchased 5 lessa plus 1 katha 18.5 lessa is equal to 2 katha and 3 lessa in dag number 93. And that dag number 93 contains 2 katha and 5 lessa only. So my exhibit A was not believed by the trial court. However, plaintiff has not adduced any evidence that he was possessing the same land which Ruma Chaudhary and Trivendra Narayan Chaudhary were competent to transfer and sell. Thus, the onus was on the plaintiff to prove that Ruma Chaudhary and Trivendra Narayan Chaudhary transferred possession of suit land from the share they received or inherited from their father, late Nipendra Narayan Chaudhary. Plaintiff was to prove that there had been a partition amongst the pattadars of Dag number 93 and patta number 32, and accordingly out of particular share of Nipendra Narayan Chaudhary, Srimati Ruma Chaudhary and Srimati Nipendra Narayan Chaudhary sold their share. In absence of it, the suit land being not demarcated, the relief of recovery of possession and permanent injunction cannot be granted to the plaintiff. So Lordship, basically it is a boundary demarcation dispute. Their Amin commission is required, Lordship, for identification of the suit land. Their purchase deed, all the purchase deeds are valid, Lordship. Only the identification of the suit lands are in dispute. We are possessing in our land, Lordship. Our case is that there is, we denied about the purchase of the defendant, plaintiff, Lordship. So now, First Appellate Court, Lordship, page 27. In issue number 3, held the defendants.
Just a minute, please. 27.
Yes, sir. Last paragraph. The issue number 3 is whether the plaintiff is entitled to declaration of right title interest over the suit land. From perusal of judgment dated passed by the learned Munsif Gwalpara in title suit number, so it appears that the learned trial court, after taking into consideration the evidence on record, decided this issue in favor of the plaintiff, declaring his right title interest over the suit land. The defendants did not challenge or prefer any appeal against the state decision arrived at by the learned trial court, deciding the issue number 3 in favor of the plaintiff. The instant appeal has been preferred by the plaintiff appellant, Khairuddin Ahmed Mullah, challenging the decision arrived at by the learned trial court in issue number 4 and 5. In support of his claim, plaintiff has examined 2 PWs and exhibited some documents. From perusal of the exhibit 1, which is the sale deed number, so it appears that the plaintiff has purchased a plot of land measuring 10 lesa from Trivendra Chaudhary and Ruma Chaudhary. From perusal of the schedule of the exhibit 1, it appears that out of total land measuring 10 lesa, 5 lesa is covered by Dag number 45293. This is the suit land project. And other 5 lesa is covered by Dag number 42494 of patta number 32, and the suit land is the land covered by Dag number 42293. From perusal of the exhibit 2, which is the certified copy of draft Chita, it appears that land measuring 2 katha 13 lesa of patta number 32, Dag number 42293 was recorded in the names of pattadar, and out of which 8 lesa land was deducted and inserted in Dag number 163. Therefore, in Dag number 42293 of patta number 32, the remaining land was 2 katha 5 lesa. From perusal of the exhibit 3, also it appears that in Dag number 93 of patta number 32, 2 katha 5 lesa land existed. The averment of the plaintiff is that he had purchased land measuring 5 lesa from Dag number 42293 in the year 2007 by exhibit 1, which is the sale deed. So from perusal of the exhibit 2, it appears that land measuring 5 lesa was recorded in the name of the plaintiff by sale deed number so in Dag
Just a
number.
minute, for this, so far as this initial 10 lectures are concerned, you say that 5 lectures are under
define
Dag
the-
number 42293.
42293 is the disputed land, Lordship.
Okay.
Another 5 lesa is 42494.
Yes, understood. So it is 42293, which should form within the dispute between the
Disputed
parties.
suit land.
So far as the other 5 lectures is concerned, that is under 424/94. That is not connected.
No. Their dispute, they have suit land is, Lordship.
5 lectures. And 5 lectures in Dag number 424. 94.
Page 7, schedule of the land is only 422.93, 5 paisa.
Yes.
So plaintiff has no dispute in regard to 424.94.
Okay.
Now, Lordship, from perusal of the exhibit 2, it appears that land measuring 5 lessa was recorded in the name of the plaintiff by sale deed 566 19/5/2007 in tag number 42293. Therefore, from the above evidence, it is clear that the plaintiff was in possession of the suit land along with right title interest over the same, because entry in the revenue record is prima facie proof of possession. From perusal of the revenue records, it appears that the name of the defendant number 2, Maleka Khatun, has not been mutated over land measuring 12.5 lessa covered by DAG number 93 or Patta number 32, purchased in the year 1997, meaning thereby that though Maleka Khatun has purchased land measuring 12.5 lessa, that is by exhibit A, Lord, covered by DAG number 93 or Patta number 32 in the year 1997, but she had no possession over the said land. From perusal of the exhibit 2, it appears that land measuring 1 kata 18.5 lessa was mutated in the name of Maleka Khatun. Therefore, land measuring 6.5 lessa remained in the DAG number 93 of Patta number 32. And out of the said land, 5 lessa land was purchased by the plaintiff and his name was mutated along with another 5 lessa of land covered by DAG number 42495 of Patta number 106. So merely on the presumption that as there remains only 6.5 lessa, so plaintiff's purchase was believed by the trial court as well as by the first appellate court. Only on that ground, Lord. Now issue number 4 and 5, page 29. The issue numbers 4 and 5 deal with the relief to which the plaintiff is entitled. The learned Munsif number 1 in the instant suit, instead of framing a separate issue on the point of disposition, took up the said point in issue numbers 4 and 5. The learned counsel for the appellant in the course of argument pointed out that the learned Munsif number 1, while discussing the issue numbers 4 and 5 in paragraph number 4, clearly stated that the fact of disposition of the plaintiff by the defendant is not denied by the defendant. This I am saying, this is the perversity, Lordship, in the
You have
petition.
shown your denial in the
Yes.
written statement.
Yes, Lordship, there is a denial. The learned counsel for the appellant further submitted that in the same paragraph, the learned trial court also took into notice that the PW1 also stated in his evidence about the disposition, but only as because the PW2 stated that he heard about the disposition, the entire evidence of the PW1 was disbelieved by the learned Munsif number 1. From the discussion made while deciding the issue number 3, it became clear that the plaintiff had possession over the suit land, and that is why his name was mutated in the revenue records. The revenue records had not been challenged by the defendants. The revenue records has not been challenged by the defendant.
Plaintiff
The
stated.
plaintiff stated that the defendants dispossessed him from the suit land in the second week of March 2012. In his cross-examination, the PW1 plaintiff stated that about 8 months ago, the defendants trespassed into his land, and at that time he called 8-10 respectable members of the society, though he did not lodge any criminal case. From perusal of the cross-examination of the PW2, it appears that he was not directly asked about the disposition. He was rather asked about the contents of the paragraph 4 of his evidence in chief, and in reply he stated that he heard about the incident stated in the paragraph number 4 of his evidence in chief, but only because of that the entire evidence of the plaintiff side cannot be brushed aside. When the plaintiff has right title and interest over the suit land and also had possession, as his name was mutated in the revenue record, had there been no incident of disposition as alleged, he would not have filed the suit. So again, presumption, Lordship. Hence, the learned Munsif number 1, Gwalpara wrongly recited the issue numbers 4 and 5
No,
against
this
the
is not a
plaintiff.
presumption. This is not a, and there is the cause of action.
No, it is a finding of the first appellate court that lordship, if he is not dispossessed, he will not file the.
Obviously, that is the cause of action for
Cause of
filing.
action, lordship, it is decided in favor of the plaintiff. I'm not on that, lordship. The dispossession part, lordship, has to be proved by the witnesses.
No, the disposition part is, but the fact of disposition, which was the cause of action for which the suit was instituted, that is only the narration.
Yes, lordship, that
It
is
is
the
not a
finding.
finding that he was dispossessed.
No, only it is the finding that he was dispossessed, so he filed the suit.
That is
Basically,
what
the
the-
first appellate court trying to say that lordship, when the plaintiff has right title interest over the suitant and also had possession, as his name was mutated in the revenue record. Had there been no incident of dispossession as alleged, he would not have filed the suit. So
Yes.
dispossession part has to be proved by witnesses, by the criminal case, lordship, with all this. With this presumption, how dispossession part can be, lordship, proved?
Yes.
Though there was no effort from the plaintiff to prove the disposition part, lordship, the first appellate court held that had there been no incident of disposition as alleged, he would not have filed the suit. So hence the learned Munsif number 1, Gwalpara wrongly decided the issue number 4 and 5 against the plaintiff. In view of the above discussion, the plaintiff is entitled to get a decree for recovery of possession along with permanent injunction. So my humble submission before your lordship, for this disposition part, there is a requirement of formulating one issue, lordship. And in this case, lordship, it is the duty of the plaintiff to sought for an Amin commission for identification of the land, lordship. Those were not done, lordship. If there is a issue decided, formulated on this point, lordship, maybe there are some other evidences to be brought on record to prove the part of disposition, lordship. Merely on the presumption part, lordship, the entire suit was decreed by the first appellate court. And there is a clear
Who are the witnesses?
PW1 is the plaintiff, lordship. He himself produces evidence, and PW2 is the Abdul Malek. PW1 and 2 I have annexed along with my appeal memo also, lordship. Annexure 5, page 34. lordship. Plaintiff he himself produced evidence as PW1, but PW2 is, lordship, Abdul Malek, son of Zainal Abedin.
Page 35,
Page 45 is PW2, lord.
45.
Yes.
Yes, please. Raj.
This is his cross part.
Yes.
I have submitted my evidence in chief on affidavit. I do not know the tag number, patta number of the suit land, but I know the boundary of the suit land between my residence and suit land. There are residents of Abdul Samad, Abdul Karim, Ibad Ali. My residence is toward north of the suit land. To the north of the suit land, the house of Nurul Islam is also situated. To the south of suit land, the land of Maleka Khatun is situated. I do not know whether Maleka Khatun is defendant or not. I do not know how much land is being owned and possessed by Maleka Khatun. I also do not know from whom Maleka Khatun purchased the land. I do not know the suit land is part of how much land belonging plaintiff is Khairuddin Mullah. I saw only execution of sale deed in favor of the plaintiff Khairuddin Mullah by Srimati Ruma Chaudhary and Sri Birendra Narayan Chaudhary. I am Bachelor of Art, but I do not remember when I passed BA. I do not know the execution of sale deed pertaining to this suit land. I practically personally do not know the suit land. The incident I stated in para 4 of my evidence in chief is my hearsay knowledge. It is not a fact that no incident as alleged in para 4 ever took place. The defendants are possessing their own land. So they are admitting my case, Lordship. My purchased lands I am possessing. This is my simple case, Lordship. The PW2, he himself admitted that
Please read again.
the defendants are possessing their own land. His own witness, Lordship. I do not know if suit land belongs to Maleka Khatun. It is not a fact that this statement is my evidence in chief or false. So he knows nothing about the sale deed of the suit land, Lordship, but indirectly he admitted that the defendants are possessing their own land. So how I
At
am,
this stage, who is in position?
my purchased lands, exhibit A, B, and C,
C.
I have purchased.
Position,
Possession, Lordship, 2 Katha 11 lesser.
which is the subject matter of these three sale deeds,
Yes.
A, B, and C.
Yes, Lordship.
And
There
he
was,
claims-
there was no challenge by the plaintiff.
And he
Lordship.
claims that in his sale deed, exhibit 1,
Lordship.
which consists of 10 lectures, it
Lordship.
includes 5 lectures from this land.
Lordship. Only 5 lesser in Dag number 422 and 993. That was encroached by us.
Who was your vendor?
My vendor, Lordship.
Was it same Ruma Chaudhary and Virendra Narayan Chaudhary?
I have to go through the statement. No, I have purchased from Sanwar Hussain. Exhibit A purchased.
Madam, how
from-
long will you take?
Lordship.
You have to continue tomorrow.
Lord. Tomorrow or day after
Tomorrow.
tomorrow.
পাঠার এটাই জন্য এটা পাঠার আছে নাকি হ্যাঁ
13 is also our item, Lordship. That is also
13 we
part-
have heard
Lordship.
কালি কালি তো হেৰি আছে না ইন্টারভিউ আছে 1 ঘন্টা লোক কালি দুটা ফিক্স করা হয়েছে এটা কিবা ম্যাটার অলরেডি করেছে
Lordship, can it be after day after tomorrow?
after tomorrow we can try but the second half this 3 days will be difficult.
Then 20, Lordship. 20 or 21. Oh, please. Yes. 20 or 21, Lordship.
But we want to be also want your submission on the provisions of law regarding not preferring an appeal than on that part of the.
Lord.
And you can have it day after tomorrow, Mr. Mahmood.
Day after tomorrow.
Yes.
Right.
In the hearing, we'll prefer this, give preference. But today you could have pointed out, we could have had Mr. Chaudhary. In fact, morning we had called. You are not there, Mr. Chaudhary.
He is not available, Lordship.
We wanted to finish off your matter. We heard for some time.
Yes.
No, it was called upon once. It will. This will have day after tomorrow. Huh?
Lord.
Paucity of time, day after tomorrow.
13 also, Lordship.
13 we'll have tomorrow at 2 o'clock. Oh, no, 13 we have tomorrow, but maintain the matter. We'll have, tomorrow it will be difficult. Tomorrow will be again motion matters. Wednesday. Day after tomorrow.
Yeah.
13.
13, Lord.
Give, no. Rest, Portmaster will give
Okay.
this
This item is day after tomorrow.
day after tomorrow.
Only Lordship, the item number 16 may not be taken up on 14th. I am not there on 14th.
16 is what?
Item number 16 is the pardon better, Lordship.
Part heard.
14th I am out of station.
Okay. Is it part heard? Which
Not
one?
that day, Lordship. Yes, both of us.
Let's be hard, it is not recorded as part, but let's be hard in that.
When do you want?
18th, Lordship.
Yeah, it will be different.
Oh. His father's Saddo is there on it.
Can it be on 20, 19
We'll try, we can try on 20, 20.
Lordship.
20. 20.
Item number 45.
Yes. No, he'll give dates.
20 Saturday.
20 of Saturday, 20 June,
Oh, sorry, 20 of Thursday. Oh,
Thursday. We'll not fix on a Saturday, will not come, you may come.